Yes, my lord. Lordship, I beg
Yes.
to mention item number 39. Lordship, on for the petitioner.
Yes.
Lordship, if this matter can come up on 17th of April.
Any difficulty today?
Yes, Lordship.
What is the difficulty?
Lordship, here I'm led by my senior, Mr. Lim Ho Bang. He said, on his instructions, I have mentioned.
There has to be a reason for adjournment, you see. You just can't fix matters from this date to that date like that. There has to be some reason. What is the reason?
Lordship,
You can very well say that he's not prepared, or you can say he has some personal difficulties.
personal difficulties, Lordship.
So you say that. Simply shifting a date, giving a date like that, there's no fun in it.
My apologies, Lordship.
As you have taken the instructions from your client to take up the matter, so you should pursue it. All right, and the prayer of Mr. Foseko Fote, Learned Counsel, who submits that he's led by Mr. Lima Wapang,
Lim Ho Bang.
who has some personal difficulties today, who might the matter be listed again after 2 weeks.
Lordship.
Yes.
Bless my lord.
Lordship, I beg to mention item number 43.
43.
Yes, Lordship. Supplementary list. If this might be pass over for today.
Why?
Lordship, I'm not prepared. today.
Same as the order yesterday.
Yes, yesterday.
It was listed yesterday, isn't it?
Yes, yesterday I was not feeling well, Lordship.
So from day to day, it's being passed over.
Tomorrow there will be no urgent, my Lordship.
So you want it after a week?
Tomorrow, Lordship.
Tomorrow?
Man.
Okay, as prayed for by Mr. Gauhati, matter is passed over for the day.
Man.
May I please, Your Lordship? My Lord, I beg to mention item number 27. My Lord, kindly allow me 3 weeks' time to file everything with my Lord.
27.
Yes, my Lord.
Who's for the other side?
And
Any
for the
objection?
answer- No, Your Lordship.
Right, as prayed for, London State Council is given 3 weeks' time to file contract list after 3 weeks. Yes,
Right,
Lord.
Lordship. May it please, Your Lordship.
Yes.
Your Lordship, I beg to mention hearing item number 33, Your Lordship. Your Lordship, here, my senior, Mr. Imti Longjam, will be arguing this matter, Lordship. However, he has some personal difficulties today, Lordship. So if this matter can come up on the 28th of April, Lordship, I have taken the consent. No objection, Your Lordship.
All right. Your good name, Miss
Lucino, Lordship.
Lucino.
Yes, Lordship.
Learned Counsel for the respondent submits that she is led by Mr. Imti Longjam.
Lordship.
And since he has some personal difficulties today, the matter may be posted again on
20 April, Lordship.
20
Yes, Lordship.
on 20 April 2023. Prayer is not objected to by the other side. As paid for is the matter for hearing again on 20 April.
Obliged, Lordship. Lordship, I also beg to mention item number 28, Lordship. Here, Lordship, I have instructions to appear for respondent number 6, Lordship, the newly pleaded party respondent, Lordship.
Yes,
So if I may be
that was
granted,
the submission last time also. Was it the last submission last time? That you will be appearing for respondent number 6.
Lordship,
And it was listed, it was directed to be listed again after a week. So why do you want adjournment?
to file my power as well as to file my counter, Lordship.
How much time?
3 weeks, Lordship.
Any objection from the other side? No, Lord. All right. Ms. Lucino, Learned Counsel, submits that she has instructions to appear on behalf of respondent number 6, and that she may be given 3 weeks' time to file her power as well as the counter affidavit. List the matter again after 3 weeks.
Much
As
obliged.
paid for. Yes.
Please, my lord.
Yes.
My lord, I beg to mention the item number, the DWC number 180 of 2022 for withdrawal on Thursday. My clients do not want to pursue this matter anymore. So this matter may kindly be listed on Thursday,
All right.
my lord.
May I please, Lordship?
Yes,
My lord, I beg to mention item number 22.
yes.
My lord, here I'm yet to file affidavit in reply. So I may be allowed 2 weeks' time to file affidavit in reply to the affidavit filed by the state as well as the private respondents.
Okay. On the prayer made by the learned counsel for the petitioner, 2 weeks' time is granted for filing the joinder affidavit to the affidavit opposition filed by the respondents.
Obliged, my lord.
Yes.
Please, Your Lordship, I beg to mention item number 9 on behalf of my colleague AIME. She's representing the state, Your Lordship. Your Lordship, here she's in bereavement, so this matter may be posted on Thursday, Your Lordship.
Some instructions was called for, isn't it, in this matter?
Your Lordship, I'm not aware, Your Lordship.
Miss A. Ayemi, is it?
Yes, Your Lordship.
Learned State Council is reported to be in bereavement on a mention made on her behalf. Matter will be posted again on Thursday. What is the date? Thursday? 30/3/2023.
Much obliged, Your Lordship.
Yes,
Bless you,
please step
Lordship.
forward. Yes,
Lordship, I beg to mention item number 1 on behalf of Vizumi. Here the state is yet to receive instructions. Lordship, we kindly list this matter after 2 weeks.
but some instructions was required to be obtained, isn't
Yes,
it?
Lordship. Yet to receive.
As paid for by the Learned State Council, matter stands adjourned for a week to receive instructions. Yes,
And Lordship, item number 10, 11, 12 on behalf of Vizumi. Lordship, we kindly list this matter after 3 weeks for admission hearing.
why?
We have some personal difficulties.
Who is appearing for this matters?
Vizumi
Limo is for the state.
for the state. Yes, Lordship.
Have you informed the other side? Have you taken the consent from the other side?
No, Lordship.
You should take consent.
And also, Lordship, item number 17,
Just a
similar
minute.
prayer.
V. Zimo, is it?
Yes, Lordship.
Mr. V. Zimo,
Ten,
Learned State
11,
Council, appearing for the state respondents.
My lord, I am for the petitioners.
Do you have objection?
I mean,
Do you have objection to the adjournment prayer? 10, 11, 12.
it's okay.
Mr. V. Zimo, Learned State Council, appearing for the state respondents, is reported to be indisposed on a prayer made on his behalf and not objected to by the opposite party. Matter stands adjourned for 3 weeks. Yes.
And Lordship, item number 17, similar prayer.
Here also, Mr. Zimo is there.
Yes, Lordship.
All right. Similar order on 17. But who's for the petitioner? You, yes. Do you have any objection?
No.
All right.
And Lordship, item number 30.
You should make the habit of obtaining their consent, all right? Later on, they should not come and say that, I don't know about this. Item 30.
Yes, Lordship. On behalf of additional G.V. Sucre, the state is yet to receive instructions. Lordship may kindly grant 3 weeks' time.
Yes.
No objection, Lordship.
All right. Similar order, 3 weeks, 30. Yes.
Obliged,
I
Lordship.
oblige.
Call the motion, ma'am.
My lord, please allow me to mention item number 5. Oh,
You're
item number
taking
19.
You're taking your time to mention. How long should I wait?
My lord,
Isn't
apologies.
it? Which item?
Item number 19.
What do you want?
Taking the consent of the opposite party. It may be fixed for hearing after 2 weeks.
You're for the petitioner,
Yes, my lord, I'm for the petitioner.
as paid for by the Learned Council for the petitioner and not objected to by the opposite party. This is the matter for admission, again after 2 weeks.
2 weeks, my lord.
19, isn't it?
Yes, my lord.
Yes, Lord.
All right.
Much obliged.
Apologies, Your Lordship, but in item 30, there's an interim order, which I forgot to mention.
30, huh? You're right. Interim order passed earlier to continue in the meantime.
Obliged, Your Lordship.
For motion.
May it please my lord.
Yes.
The lordship, in this, I'm asking for a transit anticipatory bail, lordship. My lord, my client could have traveled to Gauhati, Assam to file regular anticipatory bail, but lordship, here, because of the health problem, is unable to travel. That is the reason why we're asking for transit anticipatory bail, lordship. Now, lordship, there is strictly speaking, lordship, there is no provision in law for transit anticipatory bail as such. But different high courts in the country,
You show me an example.
Yes, Lordship.
Do you have any such kind of order?
yes, lordship. I place some authorities before you, lordship. I'm placing 3 authorities, lordship.
See, they have merely asked you to come over and give your version.
Yes, lordship,
Why
that
do
is
you-
there. That is there, lordship. But my lord, there is an apprehension that sometimes out of the blue, somebody just get detained for further interrogation as such, and my client has health issues, lordship. So he's not averse to giving cooperation to the investigation, lordship, but an apprehension that he being a public leader, lordship, his image may be tarnished, lordship. That is the main reason why this transit anticipatory bail is applied, lordship. May I take a lordship to the 2022 SCC online 463.
Yes.
Now, my lord, may kindly come to para 8. May I read, lordship?
Yes.
After hearing counsels for the parties, this court finds that there is no legislation or law which defines transit or anticipatory bail in definitive or specific terms. The 41st Law Commission report in 1969 recommended the provision of anticipatory bail to safeguard a right to life and personal liberty of a person under Article 21 of the Constitution of India. In the Code of Criminal Procedure 1973, on such recommendation, provision of anticipatory bail was inserted in Section 438. The term transit means the act of being moved from one place to another, while the word anticipatory bail means a temporary release of any accused person who is anticipating arrest. Therefore, transit anticipatory bail refers to the bail granted to any person who is apprehending arrest by police or a state other than the state he is presently located in. Then, my lord, may I kindly come to para 10. Nonetheless, transit anticipatory bail is different from ordinary bail. Ordinary bail is granted after arrest, releasing the accused from custody, while anticipatory bail is granted in the anticipation of arrest. That is, it precedes detention of the accused and is effective immediately at the time of the arrest. In plain words, when an accused is arrested in accordance with the order of the court, and whereas the accused needs to be tried in some other competent court having jurisdiction in the aforementioned matter, the accused is given bail for the transitory period, that is, the time period required for the accused to reach that competent court from the place he is arrested in. And 12, my lord, the regular court would consider such anticipatory bail on its own merits and shall decide such anticipatory bail application. Therefore, it could be easily said that the transit bail is a temporary relief which an accused gets for a certain period of time so that he or she could apply for anticipatory bail before the regular court. Then may I take a lordship to 13 again?
What will be the regular court here?
Lordship,
Regular court. In
The-
your case.
the regular court, lordship, in my case would be the principal seat, lordship, of the Gauhati High Court. Lordship, because of the health issues, lordship. My client was earlier suffering from diabetes. Then he contracted TB. And while he was battling both TB and diabetes, lordship, the severe diabetes, again,
In
yes, lordship.
that case, you could have applied for anticipated bail in the principal seat.
No, there is also a possibility, lordship, but he is a resident of Nagaland, lordship, and he is not in a position to travel. That is one reason why the transit bail became a necessity, lordship. He is actually someone to be present today, lordship. And yesterday an effort was made to be listed yesterday, but not be taken up, lordship.
Then what else?
Then may I take a lordship again to The 2022 SEC online.
No, ultimately, in this particular judgment, what has happened?
So, Lordship,
The
the
operative portion,
yeah, that is why, Lordship. May I take Lordship to para 16?
yes.
In view of the law enunciated in the above referred cases, there is no fitter on the part of the High Court in granting transit anticipatory bail. Enable the applicants to approach the courts, including high courts, where the offense is alleged to have been committed and the case is registered. There is no doubt that the right to liberty is enshrined in Part 3 of the Constitution of India, and such rights cannot be impinged except by following procedure established by law. This court finds that a commercial transaction ensued between the applicants and the complainant, and there are criminal cases lodged by the parties against each other. It is a fit case where the applicants should get the privilege of transit pre-arrest bail in the light of the order passed in the case of Nikita Jacob Supra. Then may I take a Lordship to
17.
Lordship. Hence, this court directs that in the event of arrest of applicants in connection with the FIR number so-and-so of 2022 police station so-and-so, under sections such and such IPC, they shall be released on transit bail on executing personal bond of rupees 50,000 with 2 sureties of the like amount. This application is granted for a period of 4 weeks from the date of this order to enable the applicant to approach the competent court for seeking appropriate relief.
So the FIR was registered in Jaipur, that's in Rajasthan.
Yes, in that case.
Yes, and
Lordship.
the person had approached the UP, court in UP, the High
Yes,
Court in
Lordship.
Allahabad.
Yes, Lordship. My Lord.
The FIR was filed in Rajasthan.
Yes,
Jaipur.
Lordship.
So the transit bail was granted, saying that this will be for a period of 4 weeks.
4 weeks, yes, Lordship. In fact, Lordship, last year also, towards the end of the year, the Honorable Court has granted one transit bail for one local person who was summoned in UP, Lordship. In the light of the principles laid down, Lordship.
So this
The same was
refers
appreciated.
to Nikita Jacob.
Yes, Lordship.
Let us see Nikita Jacob. 21 SEC.
21 SEC. Lordship,
Bombay High Court.
yes, 2021 SEC online, Bombay, Lordship. 13919. Has my Lord found a copy?
Yes.
May I take your Lordship to para 12? May I read, Lordship?
Yes.
I am in agreement with the view expressed by this court in the case of Javad Anand Supra and in the case of Shantanu Muluk Supra. Temporary relief to liberty, or to protect liberty and to avoid immediate arrest can be granted by this court. Generally, the powers of the High Court in anticipatory bail applications are limited to its territorial jurisdiction. However, as observed in the case of Javad Anand Supra, there may be cases where if protection is not granted, liberty of an individual would be jeopardized. The real cause of making application under Section 438 is proposed arrest of person. In the present case, there is strong apprehension of arrest. The other decisions relied upon by Mr. Such and Such are in the case of Syed Hassan Supra and Sailesh Jaiswal Supra. The courts were considering whether Section 438 of CRPC envisages grant of anticipatory bail by High Court or Court of Sessions within the country, irrespective of local commission of the offense. It was held that it cannot be done in view of territorial jurisdiction of court. The issue of transit anticipatory bail is not under consideration. The decision in the case of Navichandra Supra was delivered in different contexts, that is, the regards to exercise of writ jurisdiction under Article 226 of the Constitution of India by any High Court. These decisions were relied upon in the case of Dr. Agustin Pinto Supra. As stated above, the decision in Dr. Agustin Pinto was referred in the case of Javad Anand Supra, and in spite of that decision, protection was granted by the court, which has been confirmed by the Apex Court. The learned single judge of this court had referred criminal anticipatory bail application number 3041 of 2020 to the division bench of this court. Although the reference was not decided, Transit and anticipatory bail was granted in respect to case registered at Uttarakhand. And my lord, may I take your lordship to para 16?
Yes.
Thus, pending reference, also reliefs were granted by this court in exercise of powers under section 438 of CRPC. As stated above, the division bench has also granted such relief. The decision of Dr. Augustin Francis Pinto, Supra, and Sandeep Loharia Supra was considered by this court. As stated above, the co-accused who is apprehending arrest in this case is granted protection by Aurangabad bench of this court on 16th February 2021. The applicant has to make arrangements to seek appropriate reliefs in other state. Since the applicant would be ultimately approaching appropriate reliefs in other state, since the applicant would be ultimately approaching the merits of the case,
No, approaching the court, having jurisdiction.
or court having jurisdiction, lordship, it would not be appropriate to make any observation on the merits of the case. In the light of the factual metrics of the case, protection under section 438 of CRPC can be granted to the applicant for a temporary period of 3 weeks. May I read further, or that will be enough, lordship?
That will be enough.
Lordship. Then I have another Allahabad judgment, lordship. Where is my lord?
Not required.
Lordship. My lord, here as stated, the medical history of the applicant is annexed with the application, lordship. My lord, initially he had a problem of diabetes. And while battling diabetes, he also developed contracted TB. And in the meantime, lordship, while battling the two diseases, he also he developed an eye problem, lordship, nerve problem that damaged his eyesight. Now, he has undergone a cataract operation also, lordship, and definitely he will go and appear, lordship. There is no apprehension that there can be no apprehension on the part of the investigating agency also, because my client is a man of standing in a society. He will go and cooperate and appear, but he needs some time, lordship, for which this.
Yes, let me, who's there for the state?
Lordship, here it is for the state of Assam. So a temporary,
No.
lordship.
That is there, no doubt, but what is the view of the state PP? There's no PP here.
It's the state of Assam, lordship. So we don't have Assam's PP here.
No. Nagaland, Kohima bench has a PP, isn't it?
Yes, lordship.
So I just wanted to know from them
Lordship.
what is their view. That is why. In cases of certain issues which are important,
My lord.
the counsel concerned may not be a party to the case, but a senior counsel, a designated senior, can be asked by the court to assist the court.
Lordship.
What is your view on this? He or she may not be engaged in that case, but that is why in that, similarly, of course, you have provided the authorities here, no doubt. There's an instance last year
Yes,
of
lordship.
granting transit interim bail, transit anticipatory bail.
May I place the order passed by the Honorable Court last year?
Not required.
Lordship.
Lordship.
Yes. Just wanted to know your view. This is an application for anticipatory bail.
Lordship.
Party is state of Assam, not state of Nagaland.
Lordship.
So the issue has cropped up in Assam.
Lordship.
Have you come across such kind of case?
Lordship, I think, I don't know whether this is the right bench, Lordship.
I've been here to get enlightened. Mr. Joshua has produced three authorities, wherein the matter was from another state.
Lordship.
But the concept or the very purpose of granting interim bail or anticipatory bail is that the person should not be harassed. The person should be released. It should not be put in custody. Will be defeated if that person is asked to wait and go to that place. In the meantime, he gets arrested. There's no point. So in these cases, the court has granted anticipatory bail for a specified period, enough time for that person to go and apply for bail in that court having the jurisdiction.
Lordship.
So this is something which can be granted, I guess.
Lordship, Lordship, you know better, so I leave it to you, Mr. Mayor.
Now, since you are the PP, you should also be aware of these things. You see,
Lordship, Lordship.
it can happen vice versa also. Somebody in Gauhati may ask and ultimately come here.
Lordship.
That situation may also arise. We don't know. Please write down. Heard Mr. Joshua Seki, Learned Counsel for the petitioner, who submits that by filing this application under Section 438 CRPC, the petitioner prays for grant of anticipatory bail as he apprehends his arrest in connection with registration of Narcotics Control Bureau, crime number 02 of 2023, under Section 8, within bracket small c, read with Section 20, within bracket small b, within bracket small Roman 2, within bracket small c, and Section 29 of the ND&PS Act 1985. Stop. Next para, the Learned Counsel submits that the petitioner is a man of standing and is currently serving as the GB of Netaji Colony, Dimapur. Stop. He was surprised to receive a summons dated 14/3/2023 from the Office of the Narcotics Control Bureau, Gauhati, Assam, issued under Section 467, within bracket small c, of the ND&PS Act. Asking him to appear on 28 March 2023 at 10 a.m. before the office of the Narcotics Control Bureau, Gauhati. Stop. The summons is related to the arrest of two persons in connection with seizure of 570.807 kilograms of ganja at Gauhati. Stop. The two persons were arrested in connection with the seizure, and during the investigation, it is alleged that the contact number of the petitioner is found in the contact list of one of the alleged accused person. Stop. Hence the summons. Next para. The Learned Counsel submits that the petitioner has been undergoing medical treatment for the last 2 years on being diagnosed as with severe and uncontrolled diabetes and pulmonary tuberculosis, within bracket TB. Stop. On account of his health condition, the petitioner is not in a condition to travel immediately. Although he is willing to cooperate with the investigation. Stop. The learned counsel submits that unless some protection is granted to the petitioner, the petitioner is bound to suffer irreparable loss and injury, he being a public figure in his locality. Stop. Next para. The learned counsel further submits that since the summon has been issued by the NCB at Gauhati, the jurisdiction, the court having jurisdiction over the matter, admittedly, would be the court at Gauhati. But since the petitioner is a permanent resident of Dimapur in the state of Nagaland, he may be granted transit anticipatory bail so that the petitioner can have sufficient time and opportunity to secure anticipatory bail from the court having the jurisdiction. In support of his submission, the learned counsel has relied upon the following authorities. Number one, Amita Garg and others versus State of UP and others, 2022. Criminal Law Journal, 3350. Number two, Nikita Jacob versus State of Maharashtra, 2021 SCC online, Bombay, 13919. Next para. I have heard the learned counsel for the petitioner and perused the materials available on record, including the authorities relied upon by him. The petitioner admittedly appears to be a permanent resident of Dimapur, Nagaland, and he is also the GB of Netaji colony. Stop. Supporting certificates regarding the health condition of the petitioner has also been annexed to the petition. Stop. The Narcotics Control Bureau, Gauhati, had issued notice under section 67 within bracket small c of the NDNPS Act, requiring the appearance of the petitioner in connection with the registration of the case and investigation going on, as already referred to here and above. To stop. The said provision of law empowers the investigating authority to call for the relevant records, relevant materials, and also the person from whom information regarding the investigation can be obtained. Stop. The petitioner otherwise also contends that he is willing to cooperate with the investigation, but for his health condition and the apprehension that he'd be arrested. To stop, the High Court of Allahabad in Amita Garg and others Supra in the given facts of that case, observe that the regular court should consider grant of anticipatory bail on its own merit, but it was also not impermissible to grant transit bail as a temporary relief to the accused person for a certain period of time so that he or she could apply for anticipatory bail before the regular court. Stop. Accordingly, by relying upon the case of Nikita Jacob Supra, the High Court of Allahabad granted the protection of interim transit bail for a period of 4 weeks. So as to enable the applicant to approach the competent court for seeking appropriate relief. Full stop. Next paragraph. Thus, upon having regard to the above position, I am of the considered view that the petitioner has made out a case for grant of interim transit bail. Stop. Accordingly, it is hereby directed that in the event of the arrest of the petitioner in connection with the above noted case, he shall be released on transit bail on execution of personal bond of rupees
50,000, Lordship.
50,000 with 2 sureties of the like amount.
Lordship, one surety, if my lord may kindly.
All right, 1 surety of the like amount. Full stop. The protection is granted to the satisfaction of the arresting authority. 1 surety of like amount to the arresting authority. The protection is granted for a period of 4 weeks from the date of this order to enable the petitioner to approach the competent court for seeking appropriate relief. To stop, the petition is accordingly disposed of as allowed.
Oblige, your lordship.
For revision, item number 2.
Your lordship,
Yes.
your lordship, I filed a affidavit only this morning, and I have already served a copy to the
Received a copy just a while ago. Your Lordship.
petitioners.
Tomorrow or day after?
Day after, Your Lordship.
The learned additional AG has filed an affidavit this morning after serving a copy of the same to the other side. Full stop. As such, let the matter be listed again day after tomorrow. 30th, huh? 30th.
Item number 3.
My lord, this is third round of writ petition proceedings, my lord. In order to
Is it a short matter?
my lord, may take some time.
So So we issue rule and list it for hearing, or what? Can we issue rule and list it for regular hearing?
My lord.
Well, parties are represented by their respective councils and they submit that the pleadings are complete.
My lord.
Gustav, in view of above, let rule be issued, returnable by 4 weeks. Since the respondents are already represented, no formal notice is required. Registry to list the matter for hearing as per its own turn.
Much obliged.
Item number 4.
Yes.
May I please, Your Lordship, here the state has already filed, Your Lordship. But since the council representing the state is in bereavement, so this matter may be posted for some other,
Respondent.
for the states, Your Lordship.
For the respondent is in bereavement.
Yes, Your Lordship, the state
So-
council
so-
for the,
So what is your prayer?
on Thursday, Your Lordship, it may be posted.
Your Lordship,
This matter may come after 1 week. I'm for respondent number 4.
1 week.
Lordship.
You agree?
Your Lordship, however, the copy of the counter filed by the state is still not received as yet, physical copy. So if that
You
can
are
be
for the
produced.
petitioner.
For the petitioner, Your Lordship.
So how is it that you have not received copy?
Lordship, for respondent.
What is the
number four.
practice? Normally, one is served in advance before filing.
Lord- Lordship, similarly, when respondent 4 hasn't received a copy of the counter file, and even on the last date of when the matter was listed, similar prayer was being made, but however, till today, copy has not been filed, but
So we direct them. See, normally, before filing of affidavit, copy is served. Similarly, before filing writ petition, you serve
Lordship,
one.
yes,
Or
Lordship.
you make an undertaking that you'll serve a copy. So what is the system here? Without serving, you just file like that. Is it permissible?
Your Lordship, we undertake, Your Lordship. She must have undertaken, Your Lordship.
So I'm looking for the undertaking. I've not seen it. That's what. Second page. Oh. This affidavit. Who has not received? You have not received. And
For
what
the
about
respondent 4 and then the petitioners, Your Lordship.
For respondent, I'm for respondent number 4. I have not received.
Okay. The learned counsel for the petitioner as well as the respondent number 4 submits that they have not received the affidavit in opposition filed by the state respondents. We'll stop the state respondents to furnish a copy each to the learned counsel for the petitioner and for the respondent number 4. Is it? 4.
Yes, Lordship.
Within a week. List the matter again after 10 days.
Lordship, if the date can be fixed so that both the parties and the petitioner can also come ready and the matter can be disposed of thereafter if this honorable court permits, Your Lordship.
Just give me this calendar here. It should be it's not legible. I mean, I can't see it. Tenth. This is the matter again on 10th
Lordship,
of April.
Lordship. I'm grateful, Lordship.
Item number 5.
Yes.
My lord, on 20 April 22, the Honorable Court have directed the respondent to file additional affidavit indicating the backup marks of those candidates who are appointed. And so far, the respondent have not filed their additional affidavit.
Which date? What is the date of the order?
Date of the order 21 April 22.
21 April 22.
Yes, my lord.
Yes, Mr. Gauhati. What do you say?
Lordship, I have already filed my additional affidavit.
When? After the order of 21st of April 2022, you have filed?
Yes, Lordship. It's an additional affidavit. Lordship. And I'm very placing on record the result as directed by this Honorable Court by its order dated 21/4/2021.
Where is the affidavit? When did you file? Is it available here? What is the second copy? This is the one. Yes, have you indicated the requirements? The breakup?
Lordship, may I kindly see page 4.
Page 4.
Yes.
Yes.
Starting from serial number 13, these are all SD candidates.
Page 4.
Page 4.
Serial number?
Starting from serial number 13.
13.
1-3 years.
Who are these?
These are the SD categories, Lordship. SD.
Where do we find? Okay. Yes. Do you have a copy of the affidavit?
No, my lord.
You don't have?
No, my lord.
Hey, give him a copy. Give him a copy. We'll call it up again.
Sorry, this one.
Tomorrow or day after.
My lord, actually, as per the order, the original complaint indicating the actual breakup marks, it's only indicating the marks they obtained. Lord, I'm appearing on behalf of Entitlement Council, but I have instruction. He stated that the affidavit indicating the breakup marks is not filed. And my lord, after filing this affidavit, the Honorable Court have directed the respondent to file, have given chance. In the last order also, they have prayed for more time to file the additional affidavit indicating the breakup marks, my lord. This is not the affidavit indicating the breakup marks. This is only the marks obtained by all those candidates who are appointed. And even on the last 2-3.
What is this loose paper here? Marks obtained, results, these things are there.
Yes.
You have submitted this?
Last time during the hearing.
Did you submit this?
Yes.
So is this relevant to the issue regarding the breakup of marks?
Lordship, in fact, all the total marks are given here. And there is only 12 vacancies. And all those 12 persons who were appointed, they secured higher mark than the petitioner.
So direction was that the respondent, Union of Indian, shall file another additional affidavit indicating precisely the number of seats reserved for ST candidates for the state of Nagaland in the recruitment process, and also the list of candidates who have been appointed with the breakup marks obtained by each of them within a period of 3 weeks. So, page 4 of that additional affidavit, yes, serial number 13 onward,
yes,
it shows that they are ST.
They are ST.
Next column says fit.
Yes.
Then what is the next column? Is this the mark?
That is the mark, yes. The marks obtained by the candidates.
Correct. So these are the marks. What else do you require? Names are there. roll number, serial number, category they belong to, whether they are fit or not, and the marks obtained by them. What is your case? What is your case?
Actually, my lord, the petitioner have obtained some candidates who have obtained less marks than the petitioner were also appointed, my lord. So the
Appointed as
order-
what? As what?
Order 21 April state, although the additional affidavit filed by the Union of India on 6/4/22 has incorporated the result sheet, technical trade really November 2012, wherein it is said that 12 candidates from the state of Nagaland who scored the highest amongst the other participants among the SC category has been appointed. The result sheet does not indicate the breakup of the marks obtained by each candidate, also the 12 candidates who were selected. Therefore, the respondent Union of India shall file another additional affidavit indicating precisely the number of seats reserved for SC candidate for the state of Nagaland in the recruitment process, and also the list of the candidates who have been appointed with the breakup marks obtained by each of them within a period of 3 weeks. My lord, it is clear that the respondent has not complied with direction, and even on the last 2-3 occasions, if you take the last order, they have seek more time to file additional affidavit. So now, the opposite party claiming to have filed additional affidavit is not sufficient, my lord, for the fair adjudication of the case. And in fact, if the respondent claimed that they have filed additional affidavit, my lord, the matter may be fixed next week.
We'll do that.
Yes, my
They
lord.
don't want to file, it's up to them. Court will
Yes, my
decide on its own merit. According to Mr. Young, Sandy Younger, sorry, you are Mr. Youngawati. The affidavit is sufficient.
Yes, it's sufficient.
All right. On the prayer of the learned counsel for the petitioner, this matter again on next Thursday, Tuesday.
On Thursday, on 13th.
No, next, this is what, Kohima, it's a holiday. It has to be 4th.
On April 10th, my lord.
Huh?
April 10th.
10th of April, all right. You come prepared, just a minute. Put this inside.
Item number 6.
Your Lordship,
Yes,
Your Lordship, if this matter can come up on next Thursday, Your Lordship.
why?
Your Lordship, similar matter is going to come up tomorrow in the division bench. So after that,
Similar matter, what is the matter about?
but this is a matter relating to regularization contingency. They're asking for regularization. The petitioner appointed on a contingency basis. I'm praying for regularization, Your Lordship.
Ms. Livika, Learned State Council submits that a similar matter is pending before the division bench, and therefore the matter may be posted again after a week. List the matter again after a week.
Item number 7.
Your Lordship, here pleadings are completed, Your Lordship. So, Your Lordship, if the matter can come up after 2 weeks, Your Lordship.
Yes, what do you say?
Yes, Your Lordship.
Pleadings are, Learned Counsel for the parties submit that the pleadings are complete and that the matter may be posted for admission hearing after 2 weeks. As paid for, this is the matter again after 2 weeks for admission.
Much obliged.
Item number 8.
It will be so. May it please your Lordship.
Yes.
Your Lordship, here we are yet to file a reply to the affidavit filed by the state as well as this by response, Your Lordship. We
How
have
much
2 weeks.
time?
2 weeks, Your Lordship.
And on the prayer of Learned Counsel for the petitioner, further 2 weeks' time is granted for filing rejoinder affidavit. List again after 2 weeks.
Much obliged.
Item number 13 to 15.
Made picture or signal.
Yes, Dr. Saraf, you are in this matter?
No, this is a matter relating to.
I can't hear you.
My lord, this is a matter.
Where's the audio?
Am I audible now, my lord?
Just a
Yes.
Yes,
Can you also hear me, my lord, now?
I can hear you.
My lord, this is a matter.
But with a lot of echo. Yes.
But this is a matter where the, my lord, the petitioner is challenging the suo motu revisional notice, the suo motu revisional order, and the subsequent demand notice issued by the assessing authority, my lord.
Okay.
Now, my lord, the assessment of the petitioner was completed by the assessing authority, my lord, after due verification of the books of accounts and documents. And, my lord, after completion of the assessment, your lordship, notice was issued to the petitioner for suo motu revision. Which you lordship find at page 36.
Petitioner is the IOC.
My lord.
Yes, page 36.
Page 36, my lord, which is a notice for revision under section 20 of the Nagaland Sales of Petroleum and Taxation Act, my lord. Now, your lordship, see, it says, my lord, where despite notice forward reminders, including the last date served on you in the official mail, you have not fully complied with the terms of the notice till date. Now it appears to me, beyond reasonable doubt, that you are willfully and deliberately ignoring to comply with the terms of the notice and thereby defaulted in liable to necessary action under the appropriate provisions of the Act and the rules. Whereas cross-verification of the statements produced so far by you before this court with the records filed by you during assessment proceedings reveals the following inconsistencies. You also may kindly note it, my lord. Now, it says, my lord, Form C statement shows that there was purchase of LPG worth rupees so and so during the period. However, the sales figure as per the AOs, including tax, shows so much. The IOC record shows that it has received so much kgs of kiloliter of LPG from AOD during the period. Whether such stock was issued inclusive of tax or not and why. No trading account was made available before this court, nor filed at the time of assessment, as per IOC records. And these are the various inconsistency the divisional authority is pointing out. Your lordship may skip over and lordship may come to page 38, my lord. For different assessment years, they have given different things. And also, you see the last line, my lord. You are therefore once again called upon to appear in person or through representative duly authorized by you in writing before me on the date and time given below at my office chamber and further show in writing and with all supporting documents as to why the returns filed by you for the period should not be rejected as incorrect and incomplete and necessary action including an order under section 20 of so-and-so should not be passed against you. So, my lord, the notice was issued under section 20 of the Act. On the ground, there were certain inconsistencies, and the direction was that why the returns should not be rejected and orders should not be passed under section 20 of the Act. Now, I will take your lordship to subsequent orders, but first of all, your lordship may see section 20 of the Nagaland Petroleum Act, my lord.
Is it available? Nagaland Sales and Petroleum
My lord, I have reproduced also the petition, my lord,
Where is that?
at page 13, my lord.
1-4.
1-4, my lord.
Yes.
At the bottom, my lord.
Yes.
The commissioner may call for and examine the records of any proceedings under this act, and if he considers that any order passed therein by any person appointed under section 5 to assist him is erroneous insofar as it is prejudicial to the interest of revenue. Your lordship may kindly note, my lord, is erroneous insofar as it is prejudicial to the interest of revenue. He may, after giving the dealer an opportunity being heard, and after making or causing to be made such inquiry as he deems necessary, pass such orders thereon as the circumstances of case justify, including an order enhancing or modifying the assessment and directing a fresh assessment. Now, your lordship, the precondition for invoking the powers under section 20 of the Act is that the commissioner must come to conclusion, prima facie conclusion, that the order is erroneous insofar as the same is prejudicial to the interest of revenue. Now, the perimeter provisions have been interpreted by a division bench of this court as well as the apex court also, that what is the meaning of the term erroneous and insofar as the prejudicial to the interest of revenue. My lord, every error or every mistake would not come within the purview of the term erroneous and prejudicial to the interest of revenue. Now, I may first take a lordship to the judgments, because on that basis only the subsequent orders, what are the orders which have been passed by the authority.
Just a minute, Dr. Shah.
My lord, my lord.
Can you hear him? Are you able to hear him?
Lordship, I can hear properly.
Where are you supposed to hear? There's a screen here. Huh?
I think my learned friend is not being able to hear.
Yes, Dr. Sarah, you see, I'm hearing you, but they can't hear you properly and they can't see you also.
Oh, yeah, my lord.
So, in such circumstance, they will not know what you have submitted.
My lord,
to
absolutely
respond to
correct.
that.
Will lordship
I
fix
thought
some
there was a video or something there. Screen is not there in front of you. No, there's no screen. It's basically both of us communicating.
Yes, my lord. The other side must know that.
Without the other parties.
Yes, my lord. Other side must know that what is the argument and what is the.
See, Dr. Saraf,
My lord.
I think this might be more conducive if you have a physical hearing. You have the interim protection in your favor, I think, so far.
My lord, the interim protection is there.
So, when you are able to come here, perhaps we can have a physical hearing.
Well, last week of April, if you lordship can give some date,
Last week of April. What is the convenience of the State Government Council and you are?
Lordship, I am on behalf of Sir Ashok.
I see. You can have it on 25th of April.
25th only this, except 25th, 27th or something, This Thursday,
27th? Or?
Well, 27th.
All right. We'll have it on 27th then.
My lord, my lord.
All right. But the learned counsels for the rival parties who submit that the pleadings are complete and that the matter may be posted for admission hearing on 27th of April 2023. Accordingly, let the matter be listed for admission on 27th April 2023. The interim order passed earlier shall continue.
My lord, I'm obliged. I'm obliged, my lord.
Much obliged.
Item number 16.
Maybe Lordship. Lordship, here the matter is led by my, my senior Mr. S. Datta. He's from Gauhati. So, Lordship, if the matter can come up on 14th, Lordship.
14.
On 14th of April, Lordship.
Paid for by learned counsel for the petitioner. No, cancel that. Mr. Fosiko Fote, learned counsel, submits that he is led by Mr. S. Datta, learned senior counsel, who is from Gauhati. Stop. Since he has some personal difficulties today, matter may be posted again on 14th of April,
Lordship.
2023. The prayer is not objected to by the opposite parties. Next para. In view of above, list the matter again on 14th.
Lordship, that's in the interim. Can let the interim continue, Lordship?
2023. Stop. The interim order passed earlier shall continue till then.
Obliged, my lord.
Item number 18.
May it please, my lord. Lordship, during the pendency of this writ petition, an office memorandum issued by the Government of Nagaland Personal and Administrative Reforms Department has been brought to our notice. The present petition is also for family pension, my lord. The husband, during his lifetime, failed to nominate the petitioner.
Who's the petitioner?
She is the wife.
How many wives?
2 wives, my lord.
So this petitioner is the second wife?
Yes, my lord.
So
And it is not the case
what about
that
the first wife?
The first wife is also not in receipt of the pension. She has never received, and then she has never received, and then she is already late. She has expired.
The first one expired?
Yes, my lord.
Children?
Children, one daughter is there, but she is above the 25 years of age now.
But is she married?
Yes, she is also married.
Because unmarried daughters can get, or married daughters who have come back to their house can get.
My lord, my lord.
The
But
law
she
is
is married.
there.
She is married.
Now, what is this OM about?
My lord, it speaks about the change of nominee in the pensioner's pension book, my lord, and how the deputy commissioner must conduct an inquiry. Perhaps, my lord, the last paragraph shall be relevant for me.
You have another copy?
Yes, my lord, but the photocopy of the same only.
No, I want you to read it, that's why.
My lord, I have.
Read it.
My lord. I may read from the second paragraph then. In this regard, attention is invited to this department's office memorandum number so-and-so, wherein detailed guidelines were issued on the speedy disposal of pension and other retirement benefits, which has come into operation with effect from 4/8/2012. One of the guidelines specified in the aforementioned OM was to avoid inclusion of the name of second wife and children as nominee after the death of the pensioner in respect of settled cases. However, it is observed that many departments, without properly verifying the genuineness of the case in accordance with the guidelines issued in the office memorandum dated 4/8/2012, have been simply forwarding the petitions to Accountant General's office for extension of pensioner benefits. Therefore, it is hereby reiterated that inclusion/change of nominee, which shall also include post-retirement bilateral spouse, and children. For the purpose of family pension after the death of the pensioner in respect of settled cases shall not be allowed without proper inquiry by the Deputy Commissioner of the district. Any alteration, addition in the change of the size of the family should be immediately brought to the notice of the head of the office in the prescribed format for onward submission to Accountant General's office while the pensioner is still alive.
Which pensioner? The government servant?
Yes, my lord.
No, that is there, but what about after his death? What will happen?
My lord, here in the paragraph that I've just read, my lord, therefore it is hereby reiterated that inclusion change of nominee for the purpose of family pension after the death of the pensioner shall not be allowed without proper inquiry by the Deputy Commissioner.
Of the district?
Yes, my lord.
Okay, that is one thing.
Yes, my lord.
And the second thing is any alteration,
Yes.
addition in the size of the family should be immediately brought to the notice of the head office in the
Yes.
prescribed format for onward submission to the AG while the pensioner is still alive.
Yes, my lord.
So after he's expired, no change can be made.
That is what, my lord. Now, my lord, this
So does it not contradict the first part and the second
Yes, my
part
lord.
and second?
Exactly, my lord.
They are in contradiction.
Yes, my lord. And my lord, this OM was issued in the year 2015. The petitioner's husband expired in 1984. Way back, my lord. But due to her ignorance, my lord, and my lord, she has approached the department from early 2000, my lord. And in fact, the certain documents were also submitted before the AG's office, my lord, who are also read as respondents here. But the AG's office, my lord, they misplaced the documents. And that is how some original documents belonging to the petitioner's husband were also lost. That was in 2003. So my prayer, my lord, is, my lord, if a direction can be given, my lord, to the Deputy Commissioner to conduct an inquiry.
You have produced this 2015 OM.
Yes, my lord.
Only for the purpose of that inquiry.
Yes, my lord. And my lord, it speaks about in respect of settled cases. Now, my lord, my pension has not been settled, my lord. So, despite the fact that my pension has not been settled, my lord, an inquiry may be directed to be conducted. And if my case is genuine, my lord, then pension may be directed to be paid. Family pension, my lord, that is.
So you give me the facts. What are the facts?
Lordship, the petitioner's husband, my lord, D.K. Kupalan, he served as supervisor in the police radio organization that is under the Home Department, Nagaland, my lord.
Supervisor?
Yes, my lord, supervisor.
Supervising what?
My lord, perhaps the radio machines and the radio.
Oh, he was in the police radio organization.
Yes, my lord, my lord.
What do you call it? NPRO?
I believe so, I believe so.
Don't say that you believe so.
My lord, but it is under the Home Department, my lord. It is under the police department.
No, that I know.
Yes.
Now, what is the name of the organization? Like in other states, we have MPRO.
My lord.
What do you call it in Nagaland? NPRO. You're not.
I'm not aware, my
You're not
lord.
with proper instructions, Mr. Counsel.
I'm not aware as to whether it is called NPRO or simply Police Radio Organization, my lord. However, it is reflected in the order that.
So that there must be some document which shows that how he was appointed. Where is the appointment order?
My lord, that is what, my lord. Those documents were submitted before the AG's office. I have stated those facts, my lord, in my writ petition. I have mentioned the date on which it was submitted as well as the receipt number, my lord. However, the AG's office, they misplaced my documents. And when,
So if the documents are misplaced, what kind of inquiry can be done? You are also to produce the relevant documents.
now, Lordship, the release order, my lord, Annexure 1, the type copy is at page 28.
See, it doesn't work like that. You have to explain who was the person working, under what post, when did he join, when did he retire, then when did he have his first marriage, second marriage. See, these facts are required because the court is supposed to write some order, isn't it? We cannot
Yes.
simply say that go and make inquiry with this, as per this office memorandum.
Yes, Lordship. Now,
Can we say that with two sentences?
my lord.
So you have to explain the background.
Yes, my lord. That is why we have also filed RTI application, but the department has not been cooperating with us, my lord.
No, Mr. Counsel, don't blame the department at this stage. You're trying to make out a case
Yes,
for getting some relief from the court.
yes,
So at least you have to satisfy the court that petitioner is so and so, is the wife of late so and so.
yes, my lord.
That person was appointed in so and so, he retired on so and so.
Yes, my lord.
These basic facts are required
Yes,
in order to pass some order.
yes.
That is what I'm asking you.
Now, the release order, my lord, I have annexed. That is the
See,
page-
again, now you have gone straight to the release order.
Yes. And the application, my lord, made by the petitioner's husband while he was alive, my lord. Two different RTIs we have filed, my lord. But in both the RTI applications, which we have also annexed.
Mr. Sentianger, you still have not understood why I'm trying to tell you.
Yes, yes, lordship.
You tell me the facts.
Yes.
Don't straight away come to that he retired. You come to your paragraph 2. What have you stated?
Yes, lordship. I am filing the instant petition, my lord, praying for a direction, my lord, from this honorable court to pay me family pension, my lord. That is what I have stated, my lord. And then he was working as recolor supervisor, my lord, under the police radio organization, under Mawabchung district. And my lord, the petitioner's husband retired on 27/11/1977. Which fact is established from the handing and taking over charge report, my
You
lord?
don't know the date of appointment?
No, my lord. Because these documents, my lord, even, my lord, the succession certificate, my lord, that I have annexed in this petition, I had to obtain it for the second time, my lord. Because the original succession certificate that I have obtained from the Deputy Commissioner's office, it was lost by the Accountant General's office. They were married in the year 1982 as per Naka customs, my lord. And one daughter was born, Sintimala, who was a minor when her father expired in 1984. The petitioner is an illiterate woman. She is a villager. She is still residing in her village only.
Who was before the court? Sentimenla,
No, my lord. The wife, the second wife, my lord.
second wife.
Yes, my lord.
What happened to the first wife?
The first wife, lordship, she expired, lordship.
When?
And that information also, my lord, because since she...
So where is the statement to that effect otherwise in your petition? Now, who is this Devu?
That is the first wife.
First wife.
Yes, my lord. She is not a resident of Nagaland, my lord. She is from South India.
And the name of the daughter is Sentimenla.
Yes, the
They
name.
gave a Naga name.
The daughter of the second wife, my lord. The daughter of the petitioner, my lord. The first wife is from South India.
So what is all this confusion? Uh, Paragraph 3, you have talking about, you write about the marriage and birth of this
Yes.
daughter.
Yes. That is the daughter of the second wife and the pensioner, my lord, and the government servant.
And where's the first wife mentioned?
The first wife's name has been nominated in the pension.
Devu Kotieri.
Yes, lordship, but she has not received, my lord, the pension. She has not even claimed it,
Family pension.
to the best of my knowledge and information.
So there was a mutual agreement.
Yes.
Where is the agreement? Oral agreement.
Yes, oral agreement. In 1994, after the demise of the petitioner's husband, the first wife also came to Nagaland to meet the daughter of the petitioner, my lord. And they met and they had the discussion that the first wife, because the husband was also serving in another post, another job earlier.
What job?
In a central job, I believe. So it was agreed that, my lord, that is not the issue here, my lord. It was agreed that the first wife will receive the pension.
Must be defense.
I believe so, lordship.
There's a mention about signal corps.
Yes, my lord.
Signal corps is in the defense.
Yes, my lord.
Then?
And it was agreed that the second wife, that is the petitioner, shall receive the family pension of the service that he has rendered to the Nagaland state government. And after that, the first wife, she went back to her homestead. And since then, there has been no communication between them. However, my lord, till before 2010, my lord, one of the brothers, my lord, of D.K. Kubalan was residing in Kolkata. So they used to communicate with him, through him, my lord. And they were informed that the first wife has also expired.
So can there be two pension?
Yes, my lord.
Now you're talking about which pension here? To the police radio organization.
Yes, my lord. My lord. Lordship.
So the agreement was that the first wife will draw from the defense.
Yes, yes.
From the signal corps.
Yes, lordship.
And petitioner will draw from the thing.
Yes, lordship.
But did the petitioner draw?
No, my lord.
So when was this agreement made?
After the death of the petitioner's husband in 1984, my lord.
That was such a long time back.
Yes, lordship. And since then, she has not received any pension, my lord. Pension, my lord, can also be shared among widows, my lord, as per Rule 54, subclause 7, my lord, after CCS pension rules. And if, my lord, one of the wives dies, then, my lord, the portion which is being received by the demised wife shall be received by the surviving widow.
No, here in this case, it's a different matter.
Yes, my lord.
You're talking
Yes, my
about two pension.
Yes, my lord.
From one from the earlier
Yes, my
service,
lord. My
one
lord.
from the latter
Lordship,
service.
lordship, lordship.
So there's no question of sharing in this
Yes,
case.
yes.
She received pension for about 6 to 10 months. Is it?
That is what, my lord?
She lost the pension
Yes,
book.
yes. But these things, my lord, this is the instruction that has been given, my lord. But as I have stated in paragraph 10, my lord, and since she is illiterate, my lord, we don't know what documents has been submitted.
All right. I'll just rise for 5 minutes and come back.
Lordship.
Yes.
Yes, so my lord, the petitioner's husband served till 1977, and then his pension was settled in 1982 during his lifetime, my lord.
82.
Yes, in 1982, my lord.
82, daughter was born.
Yes, and that same year, my lord, the daughter was born, my lord. And in 1984, the pensioner expired. Now, after 1984, my lord, the widow, that is the petitioner, and the then minor daughter, my lord, they ought to have received the family pension, my lord. However, no family pension was paid to them. And by now, my lord, the then minor daughter has now become mature. She is already married. However, the petitioner she still survives, my lord. And my lord,
Para 7 of your writ petition, you say that she received pension for 6 to 10 months.
yes, my lord.
Then she lost the pension book.
Yes, my lord.
How did she receive? From where did she receive? Any details?
My lord,
And against this, what have they stated? The AG.
My lord, in paragraph 8, the Treasury Officer Mohuk Chung, my lord, has also written a particular letter, my lord, address. A certificate has been issued, my lord, which I have annexed at paragraph at annexure 8.
So, see, before that, see, I'm just asking you a few things. Paragraph 7 is your statement of having received pension
Yes.
for 6 to 10 months.
Yes, lordship. Yes.
Then you lost the pension book.
Yes.
What has the AG said here in the affidavit is that, as per the records, it is Srimati V.K. Devu,
Yes, lordship.
whose name is the nominee,
Yes, lordship.
who's the nominee of the pensioner.
Yes, lordship.
Neither the name of the petitioner nor daughter is a part of the record.
Yes.
If that is the thing, then how did you receive that pension?
Yes, lordship.
What do you mean, yes?
Uh,
How will you receive? This is only your imagination.
This is, my lord, like I have said, my lord, the widow, she is illiterate, and the best thing that she could recollect, my lord, I have put into the writ petition, my lord. And
Even if you're illiterate, you should not make stories.
Yes, lordship. And whatever documents she had at her disposal, lordship, it has been submitted to the department. On the date also I have mentioned, on 17/9/2003, under AG receipt number 2127. And my lord, without those documents, I have also extreme difficulties, lordship, to assist this honorable court, my lord. But I am also helpless. I have approached both the AG's office as well as the parent department, that is the PHQ, filing RDI, lordship. However, no documents were furnished to me.
Yes. Who's there for the AG? You have gone through this OM.
Yes, I've just received now.
Yes. Is it permissible to change the nomination, to enter the nomination after the expiry of the deceased pensioner?
Yes, Lordship. Yes, Lordship.
Permissible.
Yes, Lordship.
So why didn't you enter that? What have you stated in your affidavit?
Lordship, as far as it relates to the payment of pensioner benefits, the Office of the AG has no objection. But in order to do that, the Office of the AG can only act on the available records. Now, all the records shows that V.K. Devu is the wife of the T.K. Kopalan.
That is what you have stated.
Yes, Lordship.
But they claim that they have received pension for 6 to 10 months. Why did you give pension? 6 to 10 months.
May it please your lordship. No, lordship, that was behind our back. It was apparently done by the treasury officer Mukukshung. So we have also questioned that, but that was not in our knowledge. And as far as the change of the name of nominee after the death of the pensioner lordship, there is a procedure to be followed through it has to be routed through the deputy commissioner of the district. And that is a procedure which before reaching our office, they have to take care that all these procedural lapses are taken care of. At the end of the day, lordship, we are just an approving authority, so we have nothing against the petitioner or any other person, lordship. But they have to follow the procedure and bring the appropriate complete papers has to be submitted, lordship.
So where have you stated that it was done behind your back?
Lordship, we have not mentioned that.
Then? The petitioner has made categorical statement, paragraph
Yes,
7.
lordship.
I receive pension for 6 to 10 months, but I lost my pension book and I stopped receiving pension. And in response to that, you write that according to our records, it's Miss Srimati K. Devu,
Yes, lordship.
who is the
Yes, lordship.
nominee. If she's the nominee, then how come petitioner is receiving the pension, even for 1 month also?
True, lordship. But that was not in our knowledge, lordship.
What is this annexure A you have made? Is this a service book?
Yes, lordship. This is the record that is available with the Office of the Accountant General, lordship.
T.K. Gopalan, then class of pension. Where is the name of wife?
In the last column, lordship.
The top
Where the-
last column,
yes.
lordship. Srimati K. Devu, wife
VK, is it?
Yes,
VK.
lordship.
VK Devu.
So as per these guidelines of the government, nomination can be made. Nomination can be entered even after the expiry of the government servant.
Yes, lordship, but that is for the state to reply, lordship, because our concern is the record should be clean and clear by the time it reaches our office. We have to act according to what record is with us, and according to our records, the present petitioner is nowhere in the picture, lordship.
No, that I know. That is why he says that my name should be entered. Is it permissible?
Lordship, according to the office memorandum, it is permissible, but it has to be routed through the state authorities.
Now, state authorities, who is the state authorities here? Home Department.
Yes, lordship.
What have they said? DIG communication.
Your Lordship, here, if you may turn to page number 56 of the writ petition, Your Lordship.
I wanted to know your stand. You are taking me to the writ petition.
Mr. Lordship. Our stand is basically in this annexure, Your Lordship. This is a reply to the legal notice issued by the petitioner, Your Lordship.
Yes, yes.
In para 7, Your Lordship. It is to state that the service book of all retired employees along with pension papers are dispatched to AG Nagaland for their retirement benefits. Once the pension papers of any retired personnel is finalized by the AG Nagaland, the department is delinked and any grievances or complaint in regard to pension matters have to be taken up with the AG Nagaland Kohima, Your Lordship. So the department does not have any documents with them, Your Lordship.
So you're shifting the ball to the AG office.
And even then, Your Lordship,
AG
all
office
the-
is shifting the ball to your court,
Yes.
and you are shifting so you both are playing games.
Respectfully, Lordship, our role is limited to the record which is sent to us by the state respondents. How can they say that? In fact, in this case, if the nominee the name of the nominee is to be changed, Lordship, our role is premature, Lordship. They have to bring the entire records, clean the entire facts of the case, and bring it to the notice of the AG for approval, Lordship. For now, we are acting on the record which is available with us.
As per your records,
Lordship.
who is getting the pension?
As per records, Lordship, it is VK Devu
Who's getting the pension?
who was getting the pension, Lordship.
Still when?
I don't think so that Viket Devu ever received family pension.
We should not express our opinion, you see. The fact should speak for itself.
Lordship.
Person has retired from the police organization, radio organization, as supervisor. Then 2-3 years after that, he expires. It so happens that he had a previous wife and a subsequent wife. Correct? So you say that previous wife and subsequent wife has come to an agreement because he expired.
Yes.
That you take the pension from that signal corps. I will take pension from the police radio organization. And you claim that you are getting some pension for 6 to 10 months, but it stopped. Somehow it stopped. AG Nagaland is also saying that we are limited to our records. What records they produce here is the nomination entered in the name of the previous wife. This is not sufficient. AG Nagaland should produce the records. To whom you are giving the pension? Or since till when did you give the pension? Or you never gave pension to anybody?
Lordship,
What exactly is your stand?
Lordship, I will ask for instruction from AG and bring the last date on which the
Exactly.
yes the
So
pension will receive.
let us do that.
Lordship.
Let us wait for that. All right. We have to get to the bottom of it.
Thursday.
Please write down. The petitioner is the second wife of late T.K. Gopalan, who was working as supervisor in the police radio organization, Mokokchung, Nagaland. Stop. Sri T.K. Gopalan expired on 24/12/1984 after he retired on 27/11/1977. Stop. The petitioner claiming that the first wife has expired has sought for family pension. Stop. As per the affidavit of the AG Nagaland, the name of Srimati V.K. Devu, the first wife of the government servant, appears as the nominee of the government servant. And the name of the petitioner does not figure anywhere. Stop. However, it is not clear as to whether any pension has been paid to the pensioner himself or to his first wife, V.K. Devu. To stop, Mr. Joshua Shekhi, learned counsel appearing for AG Nagaland, shall on the next date produce the relevant records which shows that relevant records about the pension payable to the pension paid to the pensioner himself or to his nominee. List the matter again on
Third, Lordship.
my lord. Third.
Third is a Monday, Lordship.
3rd of April 2023. Yes.
Oblige, Your Lordship.
Deeply obliged, my lord.
Item number 20.
Your Lordship. Yeah, please, Your Lordship. Your Lordship, this matter is, this matter be subjected to the outcome of the SLP. Your Lordship, SLP number 19524 of 2022, wherein interim has already been granted, stay has already been granted, Your Lordship. So let this matter be subjected to the outcome.
Which item?
This COP, Your Lordship, item 20.
Contempt is against which order? Is filed for violation of which order?
Violation of, Your Lordship.
Division bench order.
Yes, Your Lordship. Division bench.
Do you have the file with you? Do you have the file with you?
Yes, Your Lordship.
Come to page 74. Is this the order? Counsel for the petitioner, you also tell us. Which order has not been complied with?
Your Lordship, it's at page 85, Your Lordship. The operative portion will be page.
No, that's okay. So this is the order, isn't it?
Yes, Your Lordship.
16/3/2022.
Yes, Your Lordship.
Which is alleged not to be complied with.
Yes, 16/3/2022, Your Lordship.
Okay, Ms. Livika, please write down. Learned State Council submits that who has filed? State.
Yes, state has filed. Your
The
Lordship.
state has filed SLP C number 19524/2022
Yes,
before
Your
the Supreme Court
Yes, Your Lordship.
against the order dated 16/3/2022 passed in WA number 9 of 2020, which is alleged to be not complied with. To stop, the Supreme Court has stayed the
Your Lordship, there's a slight clarification. The appeal is not against yes, you're right, you're right. Yes. Unconvinced, Your Lordship. My apology, Your Lordship. That is the order, Your Lordship.
The Supreme Court has stayed the order of the division bench, and therefore the matter might be adjourned for
Subject to the outcome, Your Lordship, because there's already a stay order, Your Lordship. So let it be subject to the outcome of the SLP, Your Lordship.
No. The matter, the contempt petition may be adjourned pending disposal of the SLP. You agree to the submission?
Yes, I agree, Lordship.
The submission is agreed to by the learned counsel for the petitioner. Next para. In view of above, list the matter again. After 6 weeks. Post of the learned counsel for the parties shall intimate the court on the next day about the status of the SLP. Yes.
Much obliged.
Much obliged.
Item number 21.
Lordship, on behalf of V. Jumomi, 3 weeks may be granted for filing counter.
My lord, this matter has been filed and moved on 22nd of March 2022. It's been more than a year. Oh, my lord, after more than a year, the affidavit is yet to be filed.
All right. Although Mr. Joshua Sheki has learned counsel for the petitioners has raised objection for grant of time to the respondents for filing counter affidavit. A further 3 weeks time is granted to the state respondents with an understanding that counter affidavit will be filed within the given time. List again after 3 weeks.
Yes.
Whether the matter can be heard without the affidavit, lordship?
We'll see next date.
My lordship.
So that will give an indication that you had made some objection.
Obliged, your lordship.
Item number 23.
May I please, Lordship?
Yes.
Lordship, I have a short prayer. Yesterday, we have filed an I in this writ petition, which has not been listed today. That is for amendment of this writ petition. So I pray that it may be listed tomorrow along with that IA. The IA is for amendment of this present writ petition.
You have filed it?
Yeah, yesterday we have filed it. It
What
has
is
been
it?
numbered as 32 of 2023.
Okay, what is your name?
I, Jamir.
Mr. I. Jamir, learned counsel for the petitioners.
Petitioners.
Submits that the petitioners have filed an interlocutory application for amendment of the writ petition, but the same has not been listed today. Gustav, he submits that the matter may be posted again tomorrow along with the interlocutory application. Gustav, next para in view of office to list the matter again along with the IA.
Much obliged.
Tomorrow.
Item number 24.
My lord, I filed an additional affidavit. My lord, earlier what happened is that the petitioner's extension was up to December. So your lordship has directed that the petitioner should not be asked till 30/12/2022. That is your lordship order dated 21/06/2022. 21/6/2022 in the your lordship order in the writ petition. Then according to what happened is that the petitioner, he applied for extension.
What is this 14.4? (14.4) is a part of the writ petition. Extension order.
Yes.
Let us have a look at that 14.4. 14.4. In 421, page 23. Still number 6.
My lord.
What is your engagement as? Contract,
Night Chukidar.
contract basis,
It's a fixed pay.
fixed pay,
Yes,
Science and Technology Directorate.
my lord.
So this term has expired now.
Yes, my lord. I may be allowed to take your lordship to my additional affidavit, para 5.1. Para 5 is your lordship order, which I have extracted. Additional affidavit, para 5, my lord.
Additional affidavit, when was it filed?
23/3/2023. Additional affidavit.
But I don't find the affidavit on record. There. No there. When did you file?
23/3/2023.
23, last week. It's not there. We'll list again tomorrow. If it is not here. Tomorrow. The learned counsel for the petitioner, Mr. I.N.T. Longcha, submits that the petitioner had filed an additional affidavit on 23/3/2023.
My lord.
However, the same is not found in the record. Office to verify and list the same, and list the matter again tomorrow.
Much obliged.
Item number 25.
Maybe Lordship.
Yes.
Lordship, can you grant me 3 weeks' time to file a reply to the affidavit filed by the government, Lordship?
As prayed for, 3 weeks' time is granted to the petitioner for filing reply affidavit to the affidavit of the opposition of the state respondents. List after 3 weeks.
Lordship, can let the interim continue?
Interim order passed earlier to continue.
Obliged, my lord.
Item number 26.
Yes, I please, Your Lordship.
Yes.
Your Lordship, we are here to file affidavit in reply. We pray for 2 weeks' time, Your Lordship.
Okay, further 2 weeks' time is granted to the petitioner for filing reply affidavit as prayed for. Stop list again after 2 weeks.
Much obliged.
Obliged, ma'am.
For orders, item number 29.
Lordship, in this case, I was engaged by the Legal Services Authority, Lordship, to represent the petitioner, Lordship. However, I have instruction by the client to withdraw from the case, Lordship.
To withdraw?
From the case, Lordship.
You're withdrawing from the case, or the client is withdrawing the case?
Withdrawing from the case, Lordship. The counsel is withdrawing from the case, Lordship.
And who will be the counsel?
Lordship, the client intends to engage private counsel, Lordship.
So how long should it be adjourned?
Maybe listed after 3 weeks, Lordship.
Mr. Moa Jamir, learned counsel, submits that although he was instructed to appear for the petitioner on being appointed by the State Legal Service Authority,
Lordship,
the petitioner has informed him that He or she?
She, Lordship.
She intends to.
He, Lordship.
He
I'm sorry,
intends.
Lordship.
He intends to engage a counsel of our choice. Stop. He therefore summons that he may be allowed to withdraw from the matter. Prayer is allowed. Next para. The matter stands adjourned for 3 weeks to enable the petitioner to make necessary arrangement for appointing a counsel of our choice.
Much obliged, Lordship.
For hearing, item number 31.
Lordship, there is
What about
supplementary
the
cost
entry
list.
For admission, item number 44.
Lordship, if item 44 can be called up to 45, my lord, because my learned senior counsel has been waiting for quite some time. So I don't want to keep him waiting, my lord. Obliged, my lord.
Item number 45.
Yes, Lordship.
Yes, what is your case?
Lordship may recollect this matter pertains to non-consideration of promotion on the ground of pending criminal case.
Yes, what are the basic facts?
Lordship,
Straight away. Who was the petitioner? When was he appointed? As what?
may I take your Lordship attention directly to the annexures. Lordship, annexure page 19.
19.
Page 20 is the type copy, Lordship.
What about 17?
17 is the appointment order, Lordship.
Yeah, let's see that first.
Yes.
So 18 is the type copy.
18 is the type copy, Lordship. This is the order 9th to 2003. The petitioner was appointed as ASI, Assistant Sub Inspector, Lordship.
Then
Next page, Lordship, page 19. This is order dated 25th for 2012.
let us go to the type copy.
Page 20, Lordship. He was placed under suspension in view of registration of a criminal case, Lordship. Page 21, Lordship.
Suspension is with immediate effect.
Yes, Lordship.
Page 21
Page 21.
or 22.
22 is the type copy, Lordship.
Yes.
This is the reinstatement order, Lordship, dated 15/12/2014. Mayor, Lordship.
Yes.
An order white number so dated 25/4/2012, placing ASI Longlisi Sanctum of DF Oka under suspension for his involvement in connection with the Bogor Police Station case number so. Now, therefore, the undersigned, in exercise of power conferred by sub-role so of Nagaland Service Discipline and Bill Rules 967, hereby revoke the said order of suspension with immediate effect. The period of suspension will be finalized after the outcome of the criminal case, which is taken up by the National Investigation Agency under Section 3. So, Lordship, how the petitioner was reinstated is explained at paragraph 7 of the government affidavit. Lordship, we kindly turn to government affidavit, Lordship. Before I refer to other annexures, Lordship. Government affidavit, paragraph 7.
Para 7.
Yes. Page 3.
Yes.
That, may I, Lordship?
Yes.
That, in regard to the statement made in paragraph 6 and 7 of the writ petition, the deponent denied the statement that the suspension order was revoked as nothing was found against the petitioner during the development proceeding. Query. In this regard, it may be mentioned herein that the development inquiry is completed. However, the order is kept reserved on account of the criminal proceeding being initiated against the petitioner. Also, the decision of the disciplinary authority to wait for the outcome of the criminal case was taken so that the defense of the petitioner in the criminal case may not be prejudiced as the case involved is of grave nature. It is specifically stated in the order dated 15/12/2014 that the period of suspension will be finalized after the outcome of the criminal case. Therefore, while waiting for the outcome of the criminal proceeding pending before the NIA, National Investigation Agency, the department was gracious enough to revoke the petitioner's suspension order dated 15/12/2014, as well as allow the petitioner to sit for the CVT. After the statement, Lordship,
CPT means?
Central Promotion Test. In respect of the police department, for promotion to non-gazetted posts, that is to be done through the Central Promotion Test instead of the DBC, Lordship. It is provided under the Nagaland Police Manual.
Non-gazette post.
Yes, Lordship.
Should be done by CPT.
Yes, Lordship.
Did you participate?
Yes, Lordship. I'll come to that, Lordship. Three, Lordship. General rule for promotion of non-gazetted officers.
Yes.
Lordship, relevant part is D, Lordship. Promotion to the rank of unarmed branch inspector shall be from the seniority list of the assistant sub-inspector who have qualified in the central promotion test conducted by the department for the time purpose. Promotion to the rank of armed branch, that is not relevant, Lordship. So in terms of the manual, Lordship, next page 23. Read petition page 23.
23?
Yes.
Of this manual?
No, read petition, Lordship. In terms of the provision of Rule 33, Lordship, central promotion test was conducted. Page 23, Lordship. The petitioner was allowed to sit the promotion test, and he was found qualified for promotion.
Yes.
Page 23, order dated 13 June 2018.
Where's the petitioner?
Next page, Lordship, dated 13/6/18.
No, is that serial number?
My name is serial number 42, Lordship.
52 or 53?
42. Page 23.
42?
Yes, Lordship.
What is the name?
Longlisi Sangdam.
I see.
And Lordship, subsequently, by page 25, Yes. The CBD list, which I referred to, has been slightly modified, Lordship. This is order dated, originally dated 4th December 2020. And by this original Lordship, the petitioner serial number comes to be 35. Serial number 35 is the petitioner Lordship. Yes. And Lordship, before I refer to next Lordship, serial number 36, 37, 38, 39, and 40, 40 and 42, who are tenure the petitioners, has been promoted by annexure batch 28, Lordship, annexure F.
What is the date?
Next page, Lordship, Lordship.
Date?
1st September 21.
First?
Yes, Lordship.
Signatures or second, or what?
Yes, second, Lordship.
It's not legible.
Next page, Lordship, type copy.
No, the date. I wanted to know the date.
Date is, Lordship, 2nd September, Lordship.
It looks like 1st September also. Why is it always like that? That when they sign, they give only the date and the month, no year also. And the date also is very given in a very callous manner. No? It was difficult to get that.
But this document's Lordship, which I'm referring, is to show that my junior has been promoted.
Yes, I understand. Your juniors have been promoted. So this is September. No, August. No, August has been cancelled. Now it's September.
September, Lordship. On bill, Lordship.
Promoted as sub-inspector.
Yes, Lordship.
All right.
5 junior officers were given promotion.
Five of them.
5 of them, Lordship. After the petitioner came to know about the promotion of junior officers, Lordship, the petitioner submitted a representation next page, page 30. Applying for promotion to the higher post.
Yes.
Page 33, Lordship.
Yes.
By this amendment order, Lordship, my promotion was denied. And then from that, my promotion will be considered after the finalization of the criminal case. May I read, Lordship? Page 34 is the type copy.
Yes.
Though she received so and so, Lordship. Prayer, subject reference prayer for promotion to the boss of UBSI and respect of ESL only si Songdam DF Oka dated 12/10/21. With reference to your letter to the Director General Police, nakalin for prayer for promotion to the rank of UBSI. Whereas a criminal case case number so is still going against you, and which is pending trial in the court. Hence, the matter of your promotion may be considered only after the disposal of the case by the special NI court. This is the order, Lordship. by which my promotion has been denied. On the ground that there is criminal case pending. Nothing has been mentioned in this order about that my case's promotion has been kept under seal cover. Nothing has been mentioned, Lordship. My promotion has been denied solely on the ground that there is a criminal case pending against me.
So what are the formalities required? Once you are selected by this, you have got through the CPT.
Yes.
Next thing is
For promotion, Lordship.
promotion.
Yes.
What is the involvement of this CPT? What is done in CPT? Some test is there, written test, interview like that,
Written
or
test as well as physical, Lordship. Physical test.
physical test is
Yes.
also there.
Yes.
Anywhere it is defined here, CPT, in the manual. I think CPT will require all those your knowledge about weapon, some drill, some test. Since you're a police inspector,
Lordship.
assistant sub inspector.
So, Lordship, my submission is the petitioner was allowed to participate in the central promotion test. He was qualified. Therefore, Lordship, what stops the authorities to deny promotion when my junior has been promoted? Lordship, by filing affidavit in our session,
It says on the basis of seniority list maintained by the department.
CBT itself is a seniority, Lordship.
Correct. So CPT was prepared on the basis of seniority. And those who are junior to you, 5 of them have been promoted.
Yes, Lordship. Lordship, by filing affidavit in our session,
yes,
the respondent authorities have taken a different stand, stating that my case for promotion is kept under seal cover.
Where?
Lordship, may kindly turn to Agreement affidavit.
Paragraph?
Paragraph 9th and 11th.
Seal cover.
When the result was declared in 2018 and qualified, the question of application of the seal cover procedure doesn't arise. That is my submission, Lordship. Paragraph 9. May I read, Lordship?
Where's that seal cover? Everything is in the open.
Paragraph 9, Lordship.
Yes, I've seen it.
11 also. And interestingly, Lordship, this statement at paragraph 9 and 11 is from knowledge. Lordship, may kindly turn to paragraph 13. That statement made in paragraph 1 to 12 are true to my knowledge. It's not from the record. It's an assumption of the authorities that my case is kept under seal cover, Lordship. Paragraph 9, 10, 11, all are from knowledge, Lordship. Another aspect, Lordship, why the stand-up till seal cover has been taken by the authorities, we are relying on V.V. Jangiraman case, Lordship. Reported in 1991, you see? V.V. Jangiraman case, reported in 1991, you see, Lordship. In this case, Lordship, The Honorable Apex Court laid out the principle that the seal cover procedure should be resorted to only after filing the charge sheet. That is the principle laid down in this case, Lordship. The Honorable Apex Court never said that no promotion during the pendency of criminal case. The only principle laid down in this case is that the seal cover procedure must be resorted to after filing the charge sheet. Lordship, may kindly come to which 109 is the judgment, Lordship. Relevant part is page 114. Paragraph 8. Here, Lordship.
Yes.
The common question involved in all these matters relates to what is service jurisprudence. What in service jurisprudence has come to be known as seal cover procedure. Concisely stated, the question are: 1. What is the date from which it can be said that the disciplinary criminal proceedings are pending against an employee? What is the course to be adopted when the employee is guilty in such proceeding if the guilt merits punishment other than that of dismissal? 3. That is not relevant, Lordship. Lordship, the principle laid down is in page 118. Paragraph 16. The first question, as to when, for the purpose of seal cover procedure, the disciplinary criminal proceeding can be said to have been commenced. The full bench of the tribunal has held that it is only when a charge memo in a disciplinary proceeding or a charge sheet and a criminal prosecution is issued to the employee that it can be said that the criminal prosecution is limited against the employee. The seal cover procedure is to be resorted to only after the charge sheet is issued. That is the principle laid down in this case, Lordship. The Honorable Apex Court never held that during the pendency of the criminal case, no promotion should be considered. No, Lordship.
Charge sheet, charge memo means in the
Criminal case.
criminal case.
Disciplinary proceeding has also been mentioned here, as well as the criminal case.
So what is the stage of the criminal case here? Charge
Charge
has
sheet
been framed.
already filed.
Charge has been framed.
Yes, Lordship.
That was prior to your selection
Yes, Lordship.
or after?
Prior to, Lordship. Before. CPT, Lordship.
What is the date? You qualified for the CPT.
Yes.
As per the communication of 13th June.
Yes.
Then when was the charge sheet filed?
Lordship, the criminal case is on trial stage, Lordship.
Okay, trial stage, but charge sheet was filed. That is why it is on trial.
27/1/2015.
The reason I'm referring to this judgment, Lordship, is that the respondent authorities.
27/1?
1/2015, Your Lordship.
Okay.
Otherwise, seal cover procedure doesn't apply here, Lordship. However, Lordship, the reason for referring this judgment is that the respondent authorities have taken the ground that my case is safe under seal cover. That is why I'm just trying to clarify to your Lordship that the seal cover procedure can be applied after filing the charge sheet, and the Honorable Apex Court were stated about the promotions, how the promotion to be considered. The only principle laid down in this case is that the seal cover procedures must be resorted to after filing the charge sheet. That's all, Lordship.
No, that's why the seal cover procedure is to be resorted to only after the charge memo or charge sheet is issued.
But,
So now,
but in my case, Lordship, since your Lordship has rightly pointed out, all is in open, Lordship. I was allowed to sit in the promotion phase.
Correct.
Result declared.
Because
found
this
qualified.
This is CPT. What is this CPT?
Central Promotion Test. But since the government, the responding authorities taken a stand that my case is kept under seal cover, I'm referring to this judgment, Lordship. However, Lordship, pursuant to this judgment, an advice memorandum was issued on 14th 9th 1992. By the Union of India, Lordship, Ministry of Personal Public Grievances and Pensions. I've already furnished the OM, Lordship. OM dated 14/9/1992. Yes, this OM was issued pursuant to the judgment rendered in GB Jangiraman case, Lordship. Procedure has been laid down how the seal cover procedure has to be applied and how the auto promotion should be considered. Merit, Lordship?
Yes. From where you want to read?
Lordship, the relevant part is from paragraph 4.
Read that.
It is necessary to ensure that in this OM, Lordship, Givi Jangiraman case is also reflected here in the first paragraph. First paragraph, Lordship.
Government has also noticed the judgment of the Supreme Court in Union of India versus K.V. Janikraman. As a result of the review and in supersession of all the earlier instructions, the procedure for this also is laid down.
Yes.
Was there a review of that J.V. Janakiraman's case?
There were other memorandum, Lordship, before the judgment in Givi Jangiraman case was pronounced, Lordship. After this judgment, Lordship, this OM was issued subsequently. After the Givi Jangiraman case. Paragraph 4, Lordship.
Yes, read.
It is necessary to ensure that disciplinary case criminal prosecution instituted against any government servant is not unduly prolonged, and all effort to finalize expeditiously the proceedings should be taken so that the net for giving the case of government servant is in a seal cover is limited to the barest minimum. It is therefore been decided that all the appointing authorities concerned should review comprehensively the cases of the government servant whose suitability for promotion to the higher grade has been given in seal cover on the expiry of 6 months from the date of convening the first departmental promotion committee, here in our case is a CPT, which had adjudged his suitability and give its finding in the seal cover. Such a review should be done subsequently also every 6 months. The review showed inter alia covered the progress made in the disciplinary proceeding, criminal prosecution, and further measures to be taken to expedite their completion. Number 5. In spite of the 6 months review referred to in paragraph 4 above, there may be some cases where the disciplinary case criminal prosecution against the government servant is not concluded even after expiry of 2 years from the date of meeting of the DBC, which keep its finding in respect of government servant in a seal cover. In such situation, the appointing authority may review the cases of the government servant, provided he is not under suspension, to consider the desirability of giving him a top promotion, giving in view of the following aspect. Even when the case is given under seal cover by this OM, there is some condition for a top promotion to be considered for a top promotion lordship. Even when the case is given under seal cover. In my case, lordship, I was allowed to set qualified in the promotion test, eligible to be promoted, lordship. Therefore, lordship, my submission is, what stops the authorities to deny my promotion when I'm qualified in the promotion test? In terms of this OM, lordship, even when the case is given a seal cover, eligibility and guidelines has been provided for providing promotion for ATOK. ATOK promotion, lordship.
So this A, B, C, D, E is given. These are the things which has to be ascertained.
Yes, lordship.
So at
When
any
the
rate,
case-
there has to be a review.
Yes, lordship, every 6 months.
Every 6 months there has to be a review whether person should be promoted or given a dog promotion. So
If
this has not been done in your
Yes,
case.
if the statement and the stance of the respondent authorities is considered to be true, lordship, that my case is given the seal cover, will they have followed these guidelines? No, lordship.
Now this office memorandum, is it applicable to the state?
It has been issued to all the chief secretaries, lordship. Last, do chief secretaries of all states and union territories. By this memorandum, lordship, the principle laid down in case of G.V. Jangiraman explained, lordship. So it cannot be just said that it's just a memorandum, lordship. This memorandum has been issued pursuant to the judgment rendered in G.V. Jangiraman, lordship. This honorable court also have taken into consideration of this memorandum in one of the judgment, lordship. This memorandum data given. Sorry. 2011 for GLD, lordship. Seven for eight.
Just a minute.
By this judgment, lordship, direction was issued to the state, to the authorities to consider a top promotion in view of prolonged delay in finalization of the criminal case.
Just one thing.
Yes, lordship.
What is the relevant para?
Also, it's a short judgment, lordship. May I read from paragraph 1? Relevant is paragraph 4, paragraph 7, 10, 11, and 12.
Might as well read from para 1. Let's see.
Yes, Lordship. Paragraph 1, Lordship.
Yes.
This writ bill is directed against the judgment and order dated 33/2010 passed by learned single judge in WBC number so, by which the writ petition filed by the present appellant has been dismissed. The appellant filed a writ petition bringing for direction to respond to consider his case for promotion to the next higher grade of senior manager Sable. While making the said prayer, the petitioner also prayed for a direction to the respondents to consider his case as per the standing OM Office Memorandum. The Office Memorandum is dated 14/9/1992. This is the Office Memorandum, just I prefer Lordship. In terms of which in case of any delay in finalization of the developmental criminal proceeding, the incumbent may be considered for ad hoc promotions. Part 2. In the instant case, the appellant was placed under suspension with back in 1999 by order dated 14/10/1999. Such course of action was adopted in view of the appellant alleged involvement in a criminal case launched by CBI. The said order of suspension was put to challenge by the petitioner before the Madras High Court, and the learned single judge therein having said and quashed the order of suspension, the respondent had preferred an appeal being WA number so. The appeal was also dismissed by the division bench by its order to dismiss.
We'll come back at 2.
Lordship.
Please, Lordship.
Yes.
My Lord, if I may be allowed to make a mention. My Lord, item number 31.
What do you want, 31?
My Lord, we have a consensus prayer to list the matter on 13.
On 13 as a fixed item, Lordship.
Okay, 31 list again on 13th of
April.
April 2023 as paid for by the parties.
As a fixed item, Lordship.
As a fixed item.
Obliged, Lordship.
Obliged, my Lord.
Lordship, hearing item number 34 and 35. Your Lord, let it be posted after two weeks, Your Lordship. 34 and 35.
You're for the state?
Yes, Your Lordship.
Have you informed the other side?
Yes, Your Lordship. On consensus, Your Lordship.
Okay. As paid for by the learned State Council, Ms. Livika. Appearing for the state respondents, list the matter for hearing again.
After 2 weeks, Your
After
Lordship.
2 weeks.
Your Lordship, I also beg to mention item number 36, hearing item number 36 on behalf of VG Momi.
When?
After 3 weeks, Your Lordship.
Same order, huh? 3 weeks or 2 weeks?
3 weeks, 3 weeks.
Okay, make it 3 weeks, 36.
Yeah, please, Your Lordship. Lordship, I beg to mention hearing item number 37 and 38.
Yes.
Lordship, our matter may not be reached, so kindly let this matter be posted for another date.
As paid for by the learned counsel for the appellant, list the matter for hearing again. You want a date?
Yes, Lordship. 11 or 12? 12 of
On
April.
11, on 11th of April, 2020. Tuesday.
Yes, obliged.
Request Lordship.
Yes.
Lordship, I was referring to the judgment passed
GLT.
by GLT 2011, Lordship. May I continue, Lordship?
Yes.
Paragraph 3.
Yes.
The criminal proceeding was launched against the petitioner appellant way back in 1999, and it has not attained its finality. And thus, for the 11 years, the said proceeding has become a stumbling block for the petitioner to get his promotion. There is also an indication as to when the proceeding will come to an end. It is in the above background, the petitioner has filed a writ petition bringing for the opposite relief. While doing so, the petitioner has also placed reliance on the judgment, an order dated 14/7/2018, passed by this court and publication number 3. So, it is submitted that the petitioner involvement in the said proceeding is also an employee of the respondent corporation. As in the instant case, in that case also, the petitioner was charged in the year 1999. To be precise, on 22/12/1999. Placing reliance on the aforesaid office memorandum, it was argued that in case of any delay in finalization of the criminal proceeding, the case of the petitioner is required to be considered for ad hoc promotion, if not for regular promotion, so that there is no stagnation in the service career. Accepting the said argument, the writ petition was disposed of inter alia with the following direction. Irrespective of the aforesaid aspect of the matter, if the petitioner has not been promoted due to pendency of the criminal case, the respondent may also consider case of the petitioner for promotion on ad hoc basis, taking into account of the various parameters laid down in the said office memorandum. And their exercise shall be carried out as expeditiously as possible, preferably within a period of 3 months from today. Paragraph 5. In the instant case, as noted above, the petitioner, while filing the writ petition, placed reliance on the aforesaid judgment and order, and a copy of the same and was annexed to the writ petition as Annexure M. In the counter affidavit filed by the respondent, the bearer of the petition was resisted. As regards the applicability of the aforesaid OM, there was no specific and definite denial of the applicability of the same. In paragraph 12 of the affidavit, it was stated that the said office memorandum does not have any bearing in the instant case, and as much as there is a prima facie case of involvement of criminal proceeding against the petitioner. In paragraph 8 of the counter affidavit, it was stated that the petitioner is not entitled to ad hoc promotion as per the rules of the respondent corporation, while there was no specific denial of the applicability of the office memorandum.
All right. I think the sum and substance of this judgment is that the appellate court has said that the case of the appellant should be considered.
Yes.
The petitioner should be considered in terms of this OM.
Yes.
So you're praying the same thing.
Yes.
You're praying for the same thing. OM is applicable. It is to be followed by the state.
Yes,
and if it's followed, you have to be considered for promotion, or at least for ad hoc promotion.
Yes. And the fact that, Lordship, the case is pending for 11 years. Here in this case also.
In this case, how many years?
11 years, Lordship.
No, in your case.
11 years.
11 years. Recommendation was when?
Recommendation, Lordship.
No, it was 2018.
No, criminal case, Lordship. Criminal case.
No, criminal case is something else.
Criminal case was.
What is the case number? Criminal. Is it there?
It is in the suspension order, Lordship. Page 19 of my petition. Page 19, 20 is the type copy. Developer base case number 40 of 2012.
Dipupar. Where is this Dipupar?
Dipupar, Dimapur.
Is it within the state of Nagaland or
Yes.
outside?
Yes, state of Nagaland.
Dipu is in Assam.
Yes, but Dipupar is in.
Dipupar is in Nagaland.
Yes, Lordship.
That's it. Hmm. 40 of 2012. But after this criminal case, promotion chance did not come, isn't it? First time it came only in 2018 when you sat for the CPT.
Lordship.
So you have to count from that date.
Lordship.
About 4-5 years. So that is your case.
Yes.
Some
So my
substance.
case is the criminal case was registered in the year 2012. Now we are in 2023. Therefore, it
And
is,
what is the stage?
it is on trial stage, Lordship. Lordship,
Trial stage means what exactly? The
examination of witnesses. Examination of witnesses.
How many have been examined?
Lordship, there are more than 90 witnesses, PW witnesses. Out of 90, Lordship, during 10 years, as per the information from the respondents, only 46 witnesses has been examined till date. And more than
Are you also appearing for the
Lordship
petitioner in the trial court?
Lordship.
Then you should pray for dropping of the witnesses also, isn't it? It's for speeding up.
I'm not
Supposing they don't appear,
I'm
time
not
and
in
again it's adjourned. You can pray for dropping their names. Anyway, that's a different thing.
I'm not an engaged counsel before the court bill.
Oh, you're not the engaged counsel.
Therefore, Lordship,
Yes.
when there is prolonged delay and finalization of the criminal case, ad hoc promotion is permissible. However, Lordship, by bringing the issues of seal cover procedure, the stance of the respondent is that after finalization of the criminal case, my seal cover procedure will be open, Lordship. However, my humble submission is result has been declared. I'm qualified. Therefore, the question of seal cover procedure doesn't arise. Even assuming that my case is placed under seal cover, as per the OM of 1992, guideline has been issued by the ministry how to consider a promotion when one case is kept under seal procedure. That procedure has not been followed by the respondent to this Lordship. Therefore, either way, Lordship, my ad hoc promotion should be considered in terms of the OM as well as in terms of the judgment rendered by this honorable court. So that is my short submission, Lordship.
Yes. State.
Please, Your Lordship. Your Lordship, the petitioner actually has been charged with illegal transportation of an arms and ammunition, Your Lordship. Previously, this matter has already been taken up. So I have submitted the charge sheet also, Your Lordship, just to see the gravity of the case, Your Lordship. The charge leveled against the petitioner, Your Lordship. I have submitted the charge sheet, Your Lordship. The first page will contain first information report. It will be in that bunch, Your Lordship. First information report. It will be in that bunch. Yes, Your Lordship. So if you can, if Your Lordship can kindly turn to page number 6, Your Lordship. Page number 6. Lower portion. The page number will be on the lower portion, Your Lordship.
It's not there.
Page 6.
It's not paginated.
On the left side, Your Lordship, on the left side,
It's not there.
above scanned by depth scanner, just above the scanned by depth scanner. Your Lordship.
No, it's not there. 1, 2, 3, 4, 5, 6.
Your Lordship, there will be a,
What is written?
Your Lordship, it will, on the page,
What do you want to show?
on page 4, there will be like, it will be written as National Investigation Agency, Your
1,
Lordship.
2, 3, 4.
National Investigation, yes. So starting from there, Your Lordship, page 6, Your Lordship. On the lower portion, if you,
Again, page 6.
yes, continue on the side. Your Lordship, if I can give you this copy.
You have extra copy?
Yes. Your Lordship, The copies are same, Your Lordship, so I will just exchange it and I'll show it to you, Your Lordship.
Okay. Is it there, page number?
Yes, Your Lordship. 6, Your Lordship. I've opened
No,
it.
is it there? Have
Yes,
you seen?
Yes.
It's written?
Yes, it's 6. It's written.
Okay.
So 17.1, Your Lordship.
Hmm.
May I read, Your Lordship?
Yes.
17.1. During investigation, it has been revealed that ASI Longley Se Sanctam A4 of District Executive Force Waka has collected 4,845 live rounds of 7.62 ammunition on 8/4/11 and another 4,845 live rounds of 7.62 ammunition on 24/2/12 from Police Central Store, Chumagidima, for the purpose of annual classification firing. The District Executive Force Waka is a branch of SP Office Waka functioning under the control of SP Waka Nagaland. Now, Your Lordship, we go to 17.4. 17.4. Investigation further reveals that the accused, Inhe Chekesang, Sonjong Mung Sangtam, James Ovong, and Long Sile Sangtam, that is the present petitioner, Long Sile Sangtam and another so-and-so, entered into a criminal conspiracy with common intention to commit criminal breach of trust by indulging in activities of pilferage of 7,100 live rounds of 7.62 ammunition from District Executive Force Waka to sell those ammunition for wrongful gain. The pilfered ammunition were the ammunitions which were not utilized in the annual classification firing held in the District Executive Force Waka from 14 to 16 March 2012. Another 17.5, accused Longsile Sanctam and so prepared 2 false deposit vouchers of 4,800 rounds of empty case of 7.62 ammunition against each voucher to deposit at PCS Chumagidima from the EF Waka so-and-so. Again, 17.6, accused Longsile Sanctam prepared 2 false SEF statement for the year 2011 and 2012 separately, showing 320 fires have fired 15 rounds of 7.6 ammunition by each fires in each year. That is total of 9,600 rounds of 7.62 ammunition were shown fire. Your Lordship, 17.7, I'm reading only the relevant portion, Your Lordship. As part of the conspiracy, accused Longsile Sanctam has handed over 7,100 rounds of 7.62 live ammunition to accused so-and-so on 19/4/2012 in his house, Your Lordship, at village so-and-so to sell the above live ammunition at the rate of 50 for each live rounds and to collect 50% of the sale proceed. He has collected 1,77,500 rupees from so-and-so in the morning of 24/2012 as 50% of the sale proceed of the pilfered 7,100 live rounds of 7.62 ammunition. Your Lordship, again 17.10. In the evening of so-and-so, 24/12, accused so-and-so has received 1.77 from Longsile Sanctam. That is the present petition. As sale proceed of the above pilfered ammunition, accused has kept rupees 1 lakh as his share. In the morning, 21/4/12, accused 2 has handed over the rupees 77 to Longsile Sanctam along with slip mentioning the name of police personnel and amount to be distributed to them and share of the above illegal transaction. So, Your Lordship, these are the charges that has been leveled against petitioner, Your Lordship.
What is this? This is a part of the FIR.
No, this is a charge sheet, Your Lordship.
Charge sheet.
This is a charge sheet. Initially, it was taken by the police, Your Lordship, but now the matter, since the nature is of grave nature, therefore the offense is of grave nature, and therefore the NIA has taken over the matter, Your Lordship.
Charge sheet.
Yes, charge sheet.
When was it filed?
It was filed on 27/1/2005, Your Lordship.
From where do you get the date?
Date, Your Lordship.
27/1/2015.
Your Lordship.
Last page.
Yes.
Forwarded by so-and-so SP. Signature is there.
Yes, Your Lordship. Your Lordship, thereafter, since we took up this matter last December, if I'm not mistaken, and upon inquiry, there were 97 witnesses, Your Lordship. And out of 97, 49 witnesses has already been examined, and now there's still some more remaining. And the thing is, it was there was stagnation because there was a pandemic came in, and so the trial was not able to effectively pursue. But now it is effectively being pursued, Your Lordship. So the question of slagging does not arise, Your Lordship. It is being actively pursued.
What do you say about the office memorandum?
Yes, Your Lordship, before that, before we come to the office, now the question will come whether actually the executive order will override the judicial order also, because now the petitioner has read only the piecemeal of the citation, Your Lordship. If you can come to the citation, Your Lordship.
Which one?
Janki Raman, Your Lordship. The petition has already read out. If you can kindly, Your Lordship, come to para 16. The petitioner has read only 4 or 5 lines, but if we go on, Your Lordship, we will have a clear picture, Your Lordship, of what this.
Para 16.
Para 16, if I read it again, Your Lordship.
Yes.
On the first question as to when, for the purpose of the seal cover procedure, the disciplinary criminal proceeding can be said to have commenced, the full bench of the tribunal has held that it is only when a charge memo in a disciplinary proceeding or a charge sheet in a criminal prosecution is issued to the employee that it can be said that the departmental proceeding criminal prosecution is initiated against the employee. The seal cover procedure is to be resorted to only after the charge memo charge sheet is issued. The pendency of the preliminary investigation prior to that stage will not be sufficient to enable the authorities to adopt the seal cover procedure. We are in agreement with the tribunal on this point. The contention advanced by the learned counsel for the appellant authority is that when there are serious allegations and it takes time to collect necessary evidence to prepare and issue charge memo, charge sheet, it would not be in the interest of the purity of the administration to reward the employee with a promotion. Increment does not impress us. The acceptance of the contention would result in justice to the employee in many cases, as has been the experience so far. The preliminary investigation take an inordinately long time, and particularly when they are initiated at the instance of the interested person, they are kept pending deliberately. Many times they never result in the issue of any charge memo, charge sheet. If the allegations are serious and the authorities are new in investigating them, ordinarily it should not take much time to collect the relevant evidence and finalize the charges. What is further, if the charges are that serious, the authorities have the power to suspend the employee under the relevant rules, and the suspension by itself permits a resort to seal cover procedure. The authority thus not without a remedy. It was then contended on behalf of the authorities that conclusion number 1 and 4 of the full bench of the tribunal are inconsistent with each other. Those conclusions are as follows. 1, consideration for promotion, selection grade, crossing the efficiency bar or higher scale of pay cannot be withheld merely on the ground of pendency of a disciplinary or criminal proceeding against an official. Now, number 4, the seal cover procedure can be resorted to only after a charge memo is served on the concerned official or a charge sheet filed before the criminal court, and not before. Now, the very important part is there is no doubt there is a seeming contradiction between the two conclusions, but read harmoniously, and that is what the full bench has intended. The two conclusions can be reconciled with each other. The conclusion number 1 should be read to mean that the promotion, etc., cannot be withheld merely because some disciplinary criminal proceedings are pending against the employee. Now, this is very important, Your Lordship. To deny the said benefit, they must be at the relevant time pending at the stage where charge sheet has already been issued to the employee. Thus read, there is no inconsistency in two conclusions. Your Lordship, this is the conclusion that the full bench has given, Your Lordship. Now, if the petitioner's case is in the preliminary proceeding, Your Lordship, no charge sheet has been filed and it's taken so much time, then definitely, Your Lordship, the petitioner has a right to say that, okay, he needs to be promoted. But now the question is, charge sheet has already been filed, and there is a settled law that when charge sheet has been filed, Your Lordship, promotion cannot be given. It is a well-settled law. Your Lordship, and now the petitioner has also come up with a office memorandum. Now, in office memorandum, the petitioner has said that ad hoc promotion should be given. But even if we take this thing also, because even if we take this thing, Your Lordship, it has clearly written that there should be a condition which has to be looked into before an ad hoc promotion should be given. But my contention is whether this executive order can override the judicial order, Your Lordship. No, Your Lordship, the petitioner has made a submission before this court that he has qualified for the fifth list, Lord. He has qualified for the central promotion test. But if we come to the central promotion test, Your Lordship, promotion result, Your Lordship.
Sorry?
Central promotion test result, Your Lordship.
Before we go to that, I was just going through this 17 again.
Okay, Your Lordship. So many issues has been taken up in this issue, Your Lordship.
Full bench of the tribunal, isn't it? It was the conclusion 1 and 4 of the full bench of the tribunal are inconsistent.
Yes.
Supreme Court says that it is not inconsistent. It can be read harmoniously.
Yes, Your Lord. It should
Number
be.
1 says that cannot be withheld merely on the ground of pendency of disciplinary or criminal proceeding. Then number 4,
to deny
seal-covered procedure can be resorted to only after a charge memo is served on the concerned official or the charge sheet filed before the criminal court. There is no seal. This OM also has been issued in terms of this judgment, isn't it?
Yes, Your Lordship.
So how do you pit the administrative order and the executive order and the judicial order against each other if that OM has been issued pursuant to the order of this Supreme Court?
Your Lordship, so Your Lordship, if we have to go, Your Lordship, with para 5 also, petitioner is asking for ad hoc also, Your Lordship. But it says that like, to consider the desirability of giving him ad hoc promotion, keeping in view the following aspect. If we are to take this OM,
Correct.
there
That
are
is there. That is
conditions.
there. It is not that straight away you should give a dog promotion
Yes,
or something like that.
yes,
There are certain considerations given there.
yes, Your Lordship.
A, B, C, D, E was
Yes,
there.
yes,
These are the things. And on that basis also, the government can take a call. It's not desirable to give him promotion or it's not in public interest.
yes.
All those things can be there.
Gravity should be there, Your Lordship.
But the promotion aspect cannot be kept pending without there being any surety about the conclusion of the criminal trial. That is what it says.
Your Lordship,
Because how long will that person wait? Supposing he waits for 20 years, ultimately he's acquitted then.
No, he'll get the benefit from the day he's supposed to get, Your Lordship, because now.
What is the point of getting the benefit after 20 years?
No, suppose if we, Your Lordship, the thing is that the department has also undergone a disciplinary proceedings, Your Lordship, but it has been kept in the seal cover. It has concluded, but it has been kept in the seal cover.
Which one?
Disciplinary proceeding also.
Where is that? You've never
Your
seen
Lordship,
that?
I've mentioned, Your Lordship, in my paragraph, Your Lordship, while mentioning,
No, but there are no details. There are no details.
because it's kept in a seal cover, Your Lordship.
No. Seal cover is okay, but what is the proceeding? To draw departmental proceeding, there are certain steps to be taken stage by stage. You have to appoint the inquiry officer,
Yes, Your
presenting
Lord-
officer. Have you done that?
Yes, Your Lordship.
Where is
all
that?
the, I have not submitted, Your Lordship, but all those
Then-
things are done and like, we have concluded and
No, but
even that report has been kept in the seal cover procedure and therefore that revocation has happened, Your Lordship. That is the consequent, Your Lordship. Revocation, if you can come to the revocation, Your Lordship.
no, see, from this statement given in your affidavit,
Yes,
you have
sir.
just mentioned in paragraph 9,
Yes, Your Lordship.
integrity of the petitioner has come under cloud, and therefore result of the promotion of the petitioner is withheld in a sealed cover. Result of the promotion, not departmental proceeding. These are two different things.
Your Lordship, if you can come to para 7, Your Lordship.
Yes.
Para 7, 6 and 7 of the writ petition denied the statement. The suspension order was revoked as nothing was found against the petitioner during the proceeding inquiry. In this regard, it may mention then that department inquiry is completed. However, the order is kept reserved on account of criminal proceeding being initiated against the petitioner, Your Lordship. And accordingly, we have given a revocation order, revocation of that suspension order, stating the same thing, that it will be subjected to the outcome of the criminal
Was there
petition.
a departmental inquiry
Yes, Your Lordship.
independent of the criminal proceeding?
Yes, Your Lordship.
Where is that?
Your Lordship, if I have to bring that, because since it has been kept in a seal cover procedure, Your Lordship.
You keep it in seal cover, no problem. But you have to give the details here.
Yes, Your Lordship.
That the departmental proceeding was drawn up by
Yes.
issuing this notification,
Yes, Your
so and so.
Yes, Your
This is the charge memo. He
Yes,
denied. The
Yes,
departmental proceeding concluded ultimately.
Yes, Your Lord, I can bring that.
That has to be there.
Yes,
But then how do you say that you have concluded the departmental proceeding, but you will wait for the criminal trial court's decision? How can that be?
Your Lordship, the
It
stand
can go, you know very well, it can go simultaneously. The criteria, how it is to be established is different. Criminal case has to be proved beyond reasonable doubt.
Yes, Your Lord.
Departmental proceedings can be proved by preponderance of probability. Correct?
Yes, Your Lord.
Now, it is only on cases when the charge and everything are identical with the criminal case. Then can the two go together. Otherwise, they can go independently. See, the thing that you have conducted departmental inquiry has come to light just now only.
No, we have actually stated in my, I have stated in my paragraph also, Your Lordship.
Departmental inquiry is completed.
Yes, Your Lordship.
But when did it begin?
Your Lordship, that I can produce, Your Lordship.
No, see, producing you can do, but you should have stated that in the first place. And
Your
likewise, the petitioner also should have stated, inquiry is done. I also participated. Nobody is saying anything.
Your Lordship,
So whether there was any inquiry at all or not, that is not discernible from these records. If at all you had done the inquiry, why do you wait for the criminal trial to be over? How do you justify that?
Your Lordship, actually not to. Yes, so the stand taken by the government is that not to prejudice, Your Lordship. The case of the criminal case cannot be.
No, the
prejudiced.
result you keep it in seal cover, don't show it to anybody, not even to the court. Okay. What I'm indicating is that what actually happened by which orders
Yes, that I will produce, Your Lordship.
did you appoint the inquiry officer, presenting officer, and what was the proceeding?
Your Lordship, that I will produce, Your Lordship.
Only thing you have stated that in departmental inquiry is completed.
Because everything has been in the seal cover, that's
And-
why, Your Lordship, we have not produced.
Petitioner also did not say anything about departmental inquiry.
But petitioner has already stated that the inquiry has been completed. That is
Where?
the government he has made.
You say that I'm suspended, I'm
Suspended and
suspensions
revoked, yeah.
Revoked, I'm back.
Yes, simple as that.
Para 6, Lordship. Paragraph 6.
Is it true that you have done, some inquiry was done?
Yes, Lordship.
Departmental inquiry?
Yes, Lordship.
You participated?
Yes, Lordship.
Para 6.
Para 6, I've stated criminal proceeding was initiated against the petition.
So what is kept under seal cover is the conclusion of the departmental inquiry.
Yes, Your Lordship. Your Lordship, I would also like to refer to the fit list, Your Lordship. Fit list result, Your Lordship.
Yes.
All this fit list result is subjected, Your Lordship. If you can kindly page 24, Your Lordship. The petitioner is being given an opportunity to appear for the CPT since his suspension was revoked, Your Lordship. So if we can read on the last portion, Your Lordship. The IASI kept in the fit list shall be given promotion to the rank of UABSI against vacancy or as and when vacancy arises, subject to clear annual performance assessment report apart, Your Lordship, for preceding 5 years, Your Lordship. So now the question, he might be fit, Your Lordship. The petitioner has been given an opportunity, he has qualified to be fit for promotion. However, when his APAR is questionable, Your Lordship, the promotion cannot be given to him, Your Lordship. And even the promotion to the juniors also, the same subject has been taken. Their APAR has a clear record, and therefore they have been given. Now the petitioner, if petitioner succeeds the case, Your Lordship, he will be given all the benefit from the day he's supposed to get promoted, Your Lordship. But suppose if he fails, then he will have to return back all the benefits, Your Lordship. Will not that have more weightage on him, Your Lordship? In fact, we are doing a favor to him by keeping his record in a seal cover. And so as and when his criminal proceeding is over, and if he's found not guilty, we will give all the benefit from the day he was supposed to get. But in case, if the result is vice versa, Your Lordship, this court can also take consideration on that, Your Lordship.
Subject to clear APAR,
Yes,
correct?
yes, APR.
APAR is basically ACR.
Yes, Your Lordship.
So what is his APR? It's bad.
Yes, Your Lordship, he has a record is not good, Your Lordship. It's a
So how
blemish
do you-
record.
So where is that? You have
Your
not
Lordship,
said
he has a
anything.
criminal case pending against him.
Criminal
When his
case
case
is pending. See, once, unless the person is declared to be
Yes, Your Lordship.
be guilty, he's presumed to be innocent.
Yes, Lordship, but
That is the law.
when charges has been charged against
Just
him,
because he has a criminal case, can you say he's guilty?
no, Your Lordship,
Guilty part will come later on.
that, yes, that
It
I
has to be
agree.
established.
That I agree, Your
So
Lordship.
why have you kept the seal cover? Why have you kept the department proceeding under seal cover? Because if he's acquitted, you will give him back everything. If he is found guilty, you also will find him guilty, like that.
No, Your Lordship, if he is clear from all his allegation that has been leveled against him, Your Lordship, the benefit will automatically given to him, Your Lordship, from the day he's supposed to get. But suppose, Your Lordship, if he's not,
No, that is why this OM is there, which says that there's no certainty when that criminal case will complete. It started in the year 2014. 12. And now it's more than 10 years. It's still going on. So
The magnitude of the case should also be.
No, that is
into
there, you see,
consideration,
that is
Your
there.
Lordship.
But that magnitude also cannot be the main factor, you see. On the one hand, you find him to be fit for promotion. On one hand, you say that we will wait for the criminal case trial out. So supposing the criminal trial ends after 20 years, what will you give him back 20 years of service?
Your Lordship, when the CPTs was held, Your Lordship, at that relevant period of time, he was not under suspension. So now denying him to give a CPT exam will not that amount to natural justice, or violation of natural justice. So Your Lordship, since he was not under suspension, he was also given opportunity to appear for CPT, Your Lordship.
Correct. And you found him to be fit.
Yeah, but it should be subjected to the APAR, Your Lordship. He's proceeding to 5 years, Your Lordship.
But where have you said that the APAR is bad, so we're not giving him?
Your Lordship, we have everything is in the seal cover, Your Lordship. So now
You
Your
could have
Lordship
said, you could have said that he appeared for this exam, but we will not give his result because of so and so. You could have said that. But you have declared him to be fit. In fact, you have upgraded his number also.
No,
From
but
42 he's become 35.
No, Your Lordship, in all these things, it is all like subjected to upper your only assessment.
Definitely,
proceeding
it's
to
all
5
subject.
years only.
Correct. These are basically the training thing.
Yes, Your Lordship.
This ASI, when they go for promotion to ASI, they have to write some exams. They do drill, they do weaponry, everything. Since they are personal, since they are armed forces personnel, they have to be all-round fit. So APAR will be there, of course, like any other civil government servant. Their confidential report will be there. But there is no indication here that the confidential report is bad, so we are not giving him. Your main case is that since the criminal case is pending, we are not giving him this. That's all.
No, we have just stated that the seal cover procedure has been followed, and therefore, Your Lordship, we will be giving him as and when like the criminal procedure is done. Your
Seal
Lordship.
cover is for the selection, isn't it?
No, for
But your seal cover is for the departmental inquiry.
both ways, Your Lordship, both ways. It has been kept like that is that is the stand of the government, Your Lordship.
See, despite the declaration of this result, you still say that it is under seal cover. Can it be like that? All right, what were you saying about the office memorandum? That this is not in tune with the
Your Lordship,
1991 judgment.
Your Lordship, I want to point it out that like regarding the petitioner's submission that ad hoc promotion should be given, but there are some criteria that need to be followed, where the gravity, there are some points, Your Lordship,
Correct.
that need to be into consideration. Now the petitioner's case is falling under this clause, Your Lordship. So now whether
No, that is not for the court to decide. Huh?
Yes, Your Lordship.
That is not for the court and you and me to decide that. This gravity is very, is very serious, very, very serious. So it cannot be, that has to be decided by the authority. They will say, let them speak out. Court cannot be in their shoes, no? Saying that since he's very serious, don't give him. We cannot say that. That liberty is given to the authorities to have a review whether we should give him or not. They may decide yes, they may decide no also. It's up to them. But it has to be done on regular basis, every 6 months.
Yes, Your Lordship.
The spirit behind is that the person should not be, since there's always criminal trials are very prolonged.
Yes, Your Lordship.
So why should he wait every day, counting his days, when will this case be over? That is why this thing is there. Even after considering all these aspects, authority may still deny promotion to him. That's up to them. But this consideration has to be there as per this office memorandum. And if it is applicable, why should it not be applied?
Okay, Your Lordship.
And and this office memorandum has germinated from the 1991 judgment.
Yes, Your Lordship.
So that is the aspect. So another aspect which has come into the picture is that seal cover. Now, what will happen to that seal cover? Because I was under, court was under the impression that that seal cover meant about the recommendation by this, what do you call it? CPT. Because CPT result is out already, his feet. Of course, subject to his appraisal report. But is there any order to that effect that departmental proceeding is completed, but the result is kept under seal cover? Is there any order like that?
Your Lordship, that I have to ascertain, Your Lordship.
Is there any order like that?
Specific order, Your Lordship?
It is clear from the statement made in paragraph 7 of the affidavit of association, Lordship. It is not under seal cover, it is reserved only, Lordship.
No, but that also, they have to make an order, isn't it?
Your Lordship, I will
It is
ascertain
not
that,
a
Your Lordship.
statement that the result of the developmental promotion is under seal cover. There is a statement that the result of the developmental proceeding is reserved. That's all, Lordship.
Correct, but that has to be also spoken of by way of a formal order, isn't it?
And Lordship, as I've submitted, Lordship.
Can they just keep it suspending like that?
Yes.
Your Lordship, that I have to ascertain, Your Lordship.
They may be able to do it, but there has to be an order. Otherwise, you'll have to also inquire what happened. What happened to my inquiry? Till today, you have not given any call. Where is the call? You should have asked for that also. They cannot just close up everything and keep in the almirah. To be open only when the criminal trial is over. There has to be some formal order. Although we have completed the departmental proceeding, but this proceeding will not be revealed because of the criminal trial. Something like that. It's rather unusual, isn't it? Departmental inquiry is complete. However, the order is kept reserved.
However, I was reinstated.
So we don't know what has happened to the inquiry also, whether there was inquiry at all or not. You reinstated, and during the suspension, did you enjoy the subsistence allowance?
Yes.
You got
Lordship?
subsistence allowance you received?
Yes,
you must have received, you have no complaints. But what will happen to that number of days of suspension? That will be decided depending upon the criminal case. That is what they've said. You just find out whether there's any formal order to keep the result pending like that.
Your Lordship.
Or they just kept it like that.
Your Lordship, I have to inquire. Your Lordship. I have to ascertain on that.
So two proceedings were done. One is departmental proceeding, the other one is criminal proceeding. criminal proceedings going on. As far as department proceedings is concerned, that is completed, but results have been kept in abeyance.
Yes, sir.
So how do we apply this office memorandum in such a situation? This is also another thing to be considered. Does it speak anything about the departmental proceeding in this office memorandum or in the judgment of this 1991? What about the disciplinary proceeding? Was there any disciplinary proceeding? What was how was it dealt with? In Janki Raman's case? There was no departmental proceeding in Janki Raman's case. Only that promotion was kept in abeyance because of the criminal thing.
Yes.
So there was no separate. But in the present case, there is something extra. That extra is that departmental proceeding was done, but kept in abeyance. Result kept in abeyance.
Lordship, paragraph 10 of the judgment, Lordship. Disciplinary posting has also been mentioned here. Baratat. Self-government procedure, Lordship.
Lordship, para 28, Your Lordship, on the Janki Ram.
28.
Yes, Your Lordship. 26, 27, 28.
See, in the beginning part itself, it says, what is the question posed before the Supreme Court?
Yes, Your Lordship.
Number one is, what is the date from which it can be said that disciplinary or criminal proceedings are pending against an employee?
Yes.
Number two is, what is the course to be adopted when employee is held guilty in such proceedings, if the guilt merits punishment other than that of dismissal? Number three, to what benefits an employee who is completely or partially exonerated is entitled to and from which date?
Lordship, para 28 and 29 can you give us some light, Your Lordship?
28, 29.
Yes, Your Lordship.
What exactly is that you have kept in seal cover in this case? The outcome of the departmental proceeding
Yes, Your Lordship, that is.
or the recommendation
Your
about
Lordship,
his further promotion?
Your Lordship, we have kept the result of the departmental inquiry also.
Also means?
Yes, as well as the result, Your Lordship.
No, the result here is already out. He's fit, subject to the PR.
Subject to the, that's why, Your Lordship, maybe there's some blemish record, Your Lordship, so that might be in a seal cover, Your Lordship.
PR is not it's not a secret document. He can very well apply for it. Give me my PR, they'll give him. It is not even your case that his PR is bad.
Yes, Your
Only thing is that he has to have the clearance of the PR. That's all. But your main contention is that because of that criminal trial, we're not giving him any promotion.
Yes.
And seal cover, like you said, it is regarding the departmental proceeding.
Proceedings. It is completed, but it's under the seal cover.
But this is unusual, isn't it? Very unusual. Departmental proceeding can go on its own and come to its logical conclusion. Criminal trial will take its own time, and end of the day, the court may take a call either to acquit him or to punish him. And the seal cover thing is kept at what stage? Everything is completed.
Your Lordship, the stand of the government, like to what my affidavit, to the extent of the affidavit I filed, is that like the inquiry report is, the inquiry has been completed, so it has been kept under the seal cover. Beyond that, to that extent, Your Lordship, I can make a submission, Your Lordship. Beyond that, Your Lordship, since
But there's no document before the court to show that.
Your Lordship, that's why if this court deems fit that I should submit, Your Lordship, the procedure.
Details of the proceeding.
Yes, the details, then Your Lordship, I can file it.
Petitioner is saying that I have been reinstated because they did not find anything.
No, it is subjected.
See. Very briefly, he says that they did not find anything against me. So departmental inquiry also finished and I've been reinstated. And your response is that, yes, departmental inquiry is finished, but the result is in seal cover.
Yes, that's why Your Lordship.
Beyond this, nobody has disclosed what has happened.
Your Lordship, his revocation order states that it will be subject to, Your Lordship, subject to the criminal case, Your Lordship. The revocation, Your Lordship. Revocation order, Your Lordship.
That is suspension.
Yes, that's why, Your Lordship.
But where is the departmental proceeding?
That's
it's
why,
not there.
Your Lordship, if the court feels that I need to submit, I will submit by way of affidavit, Your Lordship. Or I can produce it by record, Your Lordship. On record.
When can you produce?
Your Lordship. Short time may be given, Your Lordship. Maybe next
Court is available till Friday.
Your Lordship, can Friday, Your Lordship, possible. I'll try. The American post on Friday.
Or Thursday.
Thursday.
Day after tomorrow.
Your Lordship, I give a try, Your Lordship. I'll make an endeavor, Your Lordship. Your Lordship will also see it on 24, then if it can also post, or no, we can give a try on Thursday also, if not on 24, since Your Lordship will be sitting.
When?
24 for Your Lordship will be sitting, Your Lordship.
So then you'll file an affidavit
Your Lordship, I will do that.
showing the details. I'm not asking for the result of the seal cover, you keep it there.
Just the procedure, yes.
What procedure you have adopted? Is there any particular formal order which says that the results is not withheld because of this criminal proceeding? Is there any formal order?
Your Lordship, if that can be projected in the order, so along with the order, Your Lordship, I'll furnish the copy to the government, Your Lordship.
Please write down. During the course of the submissions made by the learned counsels for the rival parties, it has come to light that departmental proceeding was initiated against the petitioner under the relevant rules. But however, the same has been kept. The
Paragraph 7.
But however, the order is kept reserved on account of the criminal proceeding being initiated against the petitioner. Stop. It is seen that you cancel that. It is seen that there are no materials available on record as to how the departmental proceeding was proceeded with against the petitioner and whether any formal order has been passed. Keeping the outcome of the departmental proceeding in abeyance in view of the criminal proceeding. Full stop. Therefore, in order to appreciate the projection made by the parties, the state respondents shall file an additional affidavit clearly indicating the process undertaken by them in the departmental proceeding said to have been drawn up against the petitioner, along with the relevant documents. To stop, the affidavit should also indicate as to whether any formal order has been passed, keeping the result of the departmental proceeding in abeyance. Let the affidavit be filed on or before 20th of April, with a copy in advance to the other side, and the matter be listed again on 24th of April 2023.
Your Lordship, if it can fix on 25, Your Lordship.
Huh?
25, Your Lordship.
25,
Yes.
to be on the safe side.
Yes.
I'll not mention anything about part heart. Let it be like that.
Since
Lordship,
Lordship
it can be part
have
of
heard the entire matter, Lordship.
Huh?
Since Lordship have heard the entire matter, Lordship.
See,
I think
there's no issue about that, but the thing is that let us not make a formal order. And in case it's listed somewhere else, you can always mention that it's been heard by this court, like that. Just to keep the options open, we never know.
Your Lordship, let the copy be furnished to me, Your
A
Lordship.
copy of this order be furnished to Ms. Levika and State Council for doing the needful. Okay, keep like this book.
Much obliged, Your Lordship.
Item number 44.
May it please, my lord.
Yes.
Lordship, the petitioner's husband, late Gauhati, was serving as regular truck driver under the establishment of the executive engineer, PWD Road and Bridges.
Truck driver?
Yes, my lord.
Ms. Levika, you want to submit something?
Your
The
Lordship,
petitioner's husband.
Yes. What?
Your Lordship, our stand is that, Your Lordship, the petitioner has never applied for the compassionate.
Oh, I thought you want adjournment. That's
No,
why I'm asking you.
No, Your Lordship, it's very short matter. I mean, we are
No,
more.
let me hear him first.
Yeah, more or less
Okay,
admittance only.
You'll be heard. Don't worry. I'll give you a chance. Yes.
Now, my lord, while serving as truck driver under the establishment of the executive engineer, PWD Road and Bridges, Changdongya Division, Mukukchong, the petitioner's husband expired in harness on 21/1998.
Truck driver under what department?
Under PWD Road and Bridges,
I see.
under Changdongya Division, Mukukchong District.
Where are the details?
Annexure 2 is a certificate issued by the subdivisional officer, Civil Changdongya. The type copy is at page 15, Lordship. The writ petition.
When was he appointed?
Lordship, on that, we have no documents.
Don't tell me you don't even know that.
But the date certificate issued by the concerned authority has been enclosed.
So what is your prayer?
My lord, I made an application, my lord.
No, what is your prayer?
My prayer is that, my lord, I have been appointed on contract basis, my lord. So my prayer is that since I have been appointed on compassionate ground, I should have been appointed on regular basis. The state government has filed a counter affidavit, my lord, on the ground that.
No, who is the petitioner before the court? The wife?
Yes, the wife, my lord.
The wife has come to the court for seeking regularization.
Yes, my lord.
Of the services of her husband.
Yes, Lord.
Posthumously.
Not her husband, my lord, herself. She has been compassionately.
Oh, I see. She has been appointed on
Yes,
compassionate
yes,
basis.
she has been appointed on compassionate basis.
When?
On 24 April 1998.
24 April 1998.
Yes, Lordship, I have also annexed the appointment order.
Page?
At page 17, annexure 4. Type copy is at page 18, Lordship.
As what?
As work charge sweeper, contingency sweeper, work charge sweeper. Now her application for appointment is at annexure 3. Lordship, this document is important. Page 16, annexure 3, Lordship. I may be allowed to read this.
16 years.
Yes. To the Chief Engineer, PWD Road and Bridges, Nagaland, Kohima, through proper channel, subject request for a job in the department on humanity basis. Sir, with profound sorrow, I beg to lay down the following few lines for your kind consideration and necessary action. That, sir, my husband, Sri Takuwadi Ao, truck driver of PWD Changtoya Division, has been passed away on the night of 20th January 1998 after a prolonged and serious sickness, leaving 4 children under my care. They are all school going, and I am already in deep debt due to the continuous medical treatment to him. Under the circumstances, I beg to request your honor to kindly consider my case on humanity basis for providing me a small job like sweeper, kalasi, peon, etc. under the department for which my particulars are furnished hereinunder.
Yes. So on humanitarian ground, appoint
Yes.
her
Yes.
as contingency sweeper.
Yes, Lordship.
In office
And
of the PTO.
in the office of the Lordship Executive Engineer.
So you are appointed.
Yes, I am appointed.
Then-
Now, despite the word compassionate appointment not being used, my lord, the compassionate not being used, her application is on humanitarian basis, Lordship. Now, more or less, her appointment, the manner in which she had applied and the manner in which she has been appointed, it shows that she has been appointed on compassionate basis. Now, that fact is not being disputed by the respondents also, because the respondent number 5 has written a letter to the respondent number 3.
What is the criteria for compassionate appointment? Is there any policy?
Yes, Lordship.
Where is that?
That policy, Lordship.
You are trying to picture your appointment as compassionate appointment.
Yes, Lordship.
So give us the scheme. It's not annexed here.
It's not annexed here. Because we had to apply for it through RTI application, Lordship.
What is page 21? What is page 21? Revised scheme.
Yes, Lordship. This is a 2015.
This is not applicable to you.
Lordship, 2012 scheme, 2015 scheme, Lordship, 2002 scheme, all these are there, Lordship, wherein under which the, since these are beneficial legislations, the petitioner, I believe, can be accommodated. However, why the RTI information has been furnished, has been placed before this honorable court is that, Lordship, the state respondents in their affidavit in opposition came with the argument that there was no compassionate appointment scheme for the government of Nagaland when the petitioner's husband expired in 1998. And then it was only in 2002 that the government of Nagaland brought out the compassionate appointment scheme for the first time. It is mentioned in paragraph 6 of the affidavit in opposition filed by the state respondents, which is why, Lordship, we have applied for an RTI application.
Yes.
Before the BNR department. And, Lordship, the Government of India Ministry of Home Affairs Office Memorandum dated 23/5/1978, which has been adopted by the Government of Nagaland by an office memorandum dated 1/8/1978, is placed on the record of this honorable court. Now, Lordship, whether compassionate appointment scheme was applicable prior to 2002 has already been, that question has already been put to rest, my lord, by the division bench of this honorable court.
What thing?
Whether prior to 2002, compassionate appointment scheme was applicable in the state of Nagaland or not. That question was put to rest, my lord, in a judgment passed by the honorable division bench.
Citation.
2005. 4 GLD 523.
What is name?
State of Nagaland, and another versus Asino Sakre. Here, the single bench allowed the petition for regularization, considering that she has been appointed on compassionate basis. The state went for appeal before the division bench. The appeal was dismissed. Paragraph 21, my lord.
Yes, read.
May be allowed to read 21. In the instant case, the plea advanced on behalf of the appellant that in absence of any scheme of compassionate appointment, the writ petitioner cannot claim her appointment on compassionate ground is unfortunate. As noticed above, at the first instance, the state government adopted a scheme for compassionate appointment of the central government and thereafter by the office memorandum dated 13/6/1979, the decision of the government was conveyed for giving due consideration to the case for compassionate appointment.
79.
Yes, my lord. So, when the petitioner's husband expired in 21/1998.
No. The one which you gave me, this loose paper, is 1st August 78.
Yes, my lord.
So there's another one.
Yes.
Of 13/6/1979.
Yes, my lord. By that, the state government adopted the central government policy.
No, by this also they have adopted.
Yes,
which you've
lordship.
given me, 78.
Yes, lordship.
So it was adopted twice. Or what?
In lordship, in paragraph 12 of the same judgment, the memorandum has been reproduced.
No, adoption of the central government guidelines once is enough, isn't it?
Yes.
Why
my
should
lord.
it be adopted twice?
Yes, lordship.
Then
It appears in superstition of the OM dated 1/8/1978, the 13/6/1979 was issued.
any difference?
I may be allowed to read, lordship. Paragraph 12,
Where?
the last portion, at page 527 of the judgment.
It's the same thing. Son, daughter, near relative of deceased.
Yes.
This is nothing much.
Yes.
Same thing.
Yes, lordship.
You need not read. See, now you come back to page paragraph 21.
My lord.
Then where is the operative portion?
So, thus, the policy decision of the state government for providing compassionate appointment was prevalent at the time of death of the husband of the petitioner and making the application by her for consideration of her case. Now,
only thing is that it was not widely circulated. People don't know.
Yes.
People do not know that there is a scheme for compassionate appointment.
Yes, my lord.
Government on its own has already adopted.
Yes, my lord.
Now let's go to the government policy of Government of India. So this is the scheme.
Yes, lordship.
Then your husband expired in 1998.
Yes, lordship.
You were appointed in 1998 only.
Yes, lordship.
In the month of April.
Yes.
Now you are still serving?
Yes, my lord. I am still serving.
And you are asking for regularization?
Yes, my lord.
And on what basis?
Saying that, lordship, I may be allowed to refer to the decision passed by the honorable court, by this honorable court, reported in 2020 SCC online, Gauhati 4150. Paragraph 4, I may be allowed to read.
Yes.
The Deputy Secretary, PWRT, via the communication dated 33/2019, had informed that Finance Department had rejected the claim of the petitioner for regularization. Being aggrieved, the present writ petition has been instituted. Before going to any other question, we are of the view that any order on compassionate ground has to be appointed on regular basis. The claim for compassionate appointment can either be rejected or accepted as per law, but once it is accepted, the appointment is understood to be regular appointment. This court-wide judgment dated 13/3/2019 in WBC so-and-so also provided that any appointment made under the due in harness scheme under compassionate ground is to be made on regular basis.
State of Assam, they have a scheme.
In Nagaland also, my lord, that when a person is appointed on regular basis, normally they are appointed on compassionate basis. They are
So
appointed.
show me where is that in Nagaland, what is the scheme?
The scheme, my lord, I have annexed.
Revised scheme.
Yes, lordship.
Number 3, shall only be made on regular basis.
Yes, my lord.
To direct recruitment posts and only if regular vacancies meant
Yes,
for the
my lord.
purpose are available in that department. Is there any vacancy now in the PWD? How many person is reserved for compassionate appointment?
As per the latest scheme, lordship, it must not exceed 50%.
In fact, it says that ceiling of 5% is there from the direct recruitment vacancy. But this has been done away with. And
Yes, lordship.
now it should not exceed 50% of the
Yes.
vacancies during 1 year.
Yes, lordship.
If there are 4 vacancies in 1 year,
Yes.
2 vacancies
Can be out.
can
Yes.
be given to the compassionate appointees.
Yes, my lord.
So you are claiming for which year? Any specific? Or you're generally claiming that I should be regularized?
Yes, my lord.
Is there any indication anywhere that right now there are this much vacancies and I can be accommodated with this percentage?
Lordship, on that, my lord, I believe the state
what?
State will be able to give a better answer on whether there are existing vacancies.
They will be able to, but you also should also be one step ahead, saying that you already have these 10 vacancies.
Lordship.
What do you intend to do with 10 vacancies? When 5 vacancies are meant for compassionate appointment,
Yes.
I am eligible for that, you should give it to me.
Yes. Now, lordship, if my lord can kindly go to page 20, Annexure 6. Annexure 6, page 20.
6.
Yes. It seems, lordship, there are no regular sweepers in the Office of the Executive Engineer, PWD RNP. And the petitioner is the sole sweeper, and that also she is working under work charge capacity. Now I may be allowed to read this, my lord. This is a letter written by the EE to the Engineer-in-Chief.
Forwarding your representation?
Yes, my lord. With reference to the subject cited above, I am recommending and forwarding herewith an application received from Srimati Murundula, work charge sweeper under this division for grant of scale of pay and regularization from fixed pay. The applicant is serving for about 22 years on compassionate ground, consequent upon the demise of her husband, late Gauhati, who was serving as truck driver and expired on 21/1998. She is the only work charge sweeper and is sincere and devoted to her duty assigned, as there is no other regular sweeper in this subdivision. Therefore, in the light of the above circumstances, request you to look into the matter from your end. So, my lord, if she has to wait for a regular sweeper post, then since there is no regular sweeper in that particular division,
No, that's up to them to decide. See, now what has happened to this letter? 2020. This forwarding letter, what has happened?
nothing, no action has been taken, my lord.
Page, this is Annexure 6, isn't it?
Yes.
Where's the statement? It's in against statements again, paragraph 6.
Yes, my lord, paragraph 6.
What is the reply to paragraph 6? Let us see. Fixed pay employees cannot be regularized until and unless one is upgraded to the scale of pay. So, also there is no government standing policy as with regard to upgradation of scale of pay. On the other hand, granting scale of pay involves a financial implication, as there are thousands of WC fixed pay employees.
Now, paragraph 6 of the affidavit in opposition is also important, my lord.
Compassionate appointment scheme was introduced in 2002.
Yes, my lord.
Modified 2012, in 2015. And this was not applicable because petitioner was in 1998 appointed. So this is what you have already submitted.
Yes, my
Government,
lord.
State
Yes, my
Government
lord.
of India scheme has been adopted by
My
the
lord.
state government in 1978 itself.
My lord, my lord.
Later on, in 79 was further clarified.
Yes, my lord.
And since then, the various schemes have come up, revision
Yes.
and all that.
So my contention is, my lord, my stand is totally different. I am on a different footing than the other work charge employees, my lord, serving in my department. Because, my lord, I was appointed.
Otherwise, what is the general procedure? Scale of pay. From work charge, there are many cases who are asking for scale of pay.
Yes, lordship.
Minimum scale of pay.
Yes, lordship.
And those matters are pending before the DB.
Yes.
So they have been clubbed together, and those cases pending before the single bench are waiting for the outcome of the DB, isn't it? Those are the scale of pay matters.
Yes, lordship.
But here is a case,
Yes.
you're saying that this is different.
Yes, lordship.
I'm not covered by those cases. My case is different.
Yes.
I'm, in fact, a compassionate appointee.
Yes.
And I should be appointed against a regular post.
Yes, my lord.
And they say there is no scheme. In fact, there's a scheme in 1978
Yes.
by the government of India, which is
Yes.
also adopted by the state government.
Yes, my lord.
So that is your submission.
Yes, my lord. In the judgment that I have also placed, my lord, the judgment reported in 2005 for GLD 531, in paragraph 27 also, lordship, a similar stand was adopted, lordship, by the state government, saying that if her case is considered, then the other 109 employees will also have to be considered. I may be allowed to read paragraph 27, my lord. From the discussions made above, there is no escape from the conclusion that the petitioner deserves special consideration. But the appellants, instead of discharging their duties as a model employer, took recourse to untenable pleas. The apprehension of the appellants is that if the directions contained in the impugned judgment and order are to be implemented in respect of the petitioner, the other casual employees, numbering 109, might also fall in queue seeking similar directions. Such appreciation can well be taken care of, making it clear that the case of the petitioner falls altogether in a different category, and that the directions contained in the impugned judgment and order was only confined to the case of the petitioner. For the foregoing reasons and discussions, we are of the considered opinion that no interference is called for to the impugned judgment and order. Consequently, the writ appeal stands dismissed.
Okay, that is your case.
My lord.
Let me hear
My lord.
the other side.
Deeply obliged.
Lordship.
Initially, you were seeking adjournment or what? What did you want to say?
Initially, the stand of the government was that the petition was appointed on WC contingency in the year 1998.
Yes.
And they have never applied under the compassionate scheme because the compassionate scheme came into operation only on the year 2002. That was our contention. Your Lordship, however, the petitioner refuted by filing a counter affidavit by submitting this ruling, Your Lordship, stating which is self-explanatory now. I don't have to go there. So it's admitted, Your Lordship, that okay, there was an operation of a compassionate scheme adopted by the central, which was automatically adopted by the state. So, Your Lordship, now the question is now, first thing, now the petitioner is praying for regularization, and the petitioner they have never applied under the compassionate scheme, though impliedly they are stating that they have been appointed under a compassionate scheme, but never applied. Now we have an addendum, Your Lordship. We have an addendum. If you can kindly come to my annexure 11, page 11 of my affidavit in opposition, Your Lordship.
Yes.
Now, in this addendum, the compassionate appointment has to be there. There has to be a list, Your Lordship, and these lists are being maintained in the order of death, Your Lordship. Now, the technical issue is that the petitioner, they have never applied under the compassionate scheme. Now, they will never be under the list also, Your Lordship. So that is one technical issue. And another is that, Your Lordship, the petitioner, they are praying for regularization. Now the petitioner is under contingency, Your Lordship. Now whether the contingency, the post that the petitioner is holding right now is against a sanctioned post or not, Your Lordship, that is a thing. Now if it's against a sanctioned post, maybe we can, that the court, maybe we wouldn't have an objection for direction to consider for regularization, Your Lordship. But suppose if this court gave a direction for regularization against this post, and if there was no sanctioned post against this post, again, that will create another technical problem, Your Lordship. So there are a few technical issues. Otherwise, we are in an admitted position now, Your Lordship.
What does the appointment order say?
Appointment is on contingency, Your Lordship.
There's nothing about there being a sanction post.
Against a sanction, there's no mention of against a sanction post. So that is again.
She can be adjusted against any post. What is there? Can you say that I should be given this post should be made a sanction post?
No, my lord.
So it should be against any sanction post.
Yes, my lord.
There's no issue about that. She cannot claim that this post, contingency post, would be made a regular post, a sanction post, and I should be kept there.
Okay, Lordship.
All that she can say is that I should be considered for compassionate appointment in terms of the scheme.
Yes, Lord.
Since I was appointed on so and so,
Yes, Lord.
well, and the scheme was prevailing. So it's up to the state or the department to see where she can be adjusted. That is the thing.
Yes, Lord.
I mean, she cannot demand everything, na? So we'll accordingly dispose of in that direction.
Your Lordship, 6 months will be granted to us so that that procedure can be taken up. If the court is
6
take of
months?
consideration. Yes, sir. Because regularization, you have to see, as you have said, we have to accommodate that there's a procedure also. So at least 6 weeks, 6 months, Your Lordship.
6 months is a very long time. We'll make it slightly shorter. Kindly call the steno. This is item 44, is it?
Yes, my lord.
44.
Yes, sir.
Heard Mr. Sentianger, learned counsel for the petitioner, and Ms. Devika, learned state counsel, appearing for the state respondents. Having regard to the nature of the case projected by the petitioner, as well as the respondents, the petition is taken up for disposal at this stage. Stop the next paragraph. The husband of the petitioner, while working as truck driver under the executive engineer, Public Works Department, Changtungya Division, is it?
Yes, my lord. PWD RNP bridges, my lord.
PWD within bracket R&B Changtungya Division expired on 1998 after prolonged illness. Most of the petitioner, as wife of the late government servant, submitted an application. Where is your application?
Annexure 3, my lord, page 16 to the writ petition.
To the chief engineer, PWD, within bracket R&B, through proper channel. Asking for her appointment on humanitarian ground. Stop. She was accordingly appointed. White Office Order dated 24/4/1998. As work charge contingency sweeper at the rate of rupees 750 per month. Full stop. Ever since her appointment, the petitioner has been working as such till date. Next paragraph, the petitioner on 26/2/2020 submitted an application to the Engineer-in-Chief, NPWD, Nagaland, Kohima, through proper channel, requesting for grant of scale of pay and for regularization of our service, stating that she has been working for the last 22 years under the establishment of the Sub-Divisional Officer, PWD, within bracket R&B, at Changtongya. Top, the application of the petitioner was forwarded by the Executive Engineer, PWD, R&B, Changtongya Division, to the Engineer-in-Chief, NPWD, Nagaland, Kohima, on 16/4/2020. Stating that there is no other regular sweeper in the subdivision, and therefore the application of the petitioner be favorably considered. Stop. However, the same has not been considered by the respondents. Respondent authority. You cancel that. However, the same having not been considered by the respondent authority, the petition is before this court. Next paragraph. Mr. Senti and the learned counsel submits that although the appointment of the petitioner as contingency sweeper on fixed pay does not indicate that she was appointed on compassionate basis, but the fact remains that the husband of the petitioner expired during while serving as truck driver under the department concerned, and on that account, the petitioner was given appointment on humanitarian ground. To stop. Therefore, for all intended purpose, the same can only be understood as an appointment made on compassionate basis. To stop. The learned counsel submits that the state government, now the Government of India Ministry of Home Affairs in the Department of Personal and Administrative Reforms on 23/5/1978 had issued an office memorandum on the subject compassionate appointments of government of son/daughter/near relative of deceased government servant, consolidated instruction. You put that within inverted comma. Full stop. As per the office memorandum, the guidelines and the manner in which the compassionate appointment is to be made has been provided. To stop this office memorandum has been adopted by the government of Nagaland. White Office Memorandum dated 1/8/1978, issued by the Department of Personnel and Administrative Reforms, Administrative Reforms Branch, White Memo number AR-8/8/78. The Government of India Office Memorandum has also been further adopted. White
Page 5227.
Office Memorandum dated 13/6/1979, issued by the same department, White Memo number AR-8/8/78. To stop, it is therefore clear that there existed relevant guidelines for appointment on compassionate basis. To stop, this aspect of the matter has also been put at rest by a division bench of this court in State of Nagaland and another versus Asino Sakri, reported in 2005 for GLT 523. Stop. He therefore submits that full stop. He therefore can cancel that. The next paragraph. The Lauded Council further submits that an appointment on compassionate basis has to be on regular basis. To stop, this aspect of the matter is clear from the relevant scheme issued by the state government from time to time, including Office Memorandum dated 17/9/2015, issued by the Personnel and Administrative Reforms Department, within bracket, Administrative Reform Branch, White Memo number AR-8/8/78, under the subject, open inverted comma, revised compassionate appointment scheme for state government employees who die in harness. Stop. Therefore, it is a fit case for therefore, the respondent authorities should be directed to appoint the petitioner against a regular post. In support of his submission, the learned counsel has also relied upon the case of Ashmiadhar versus State of Assam, reported in 2020, SCC Online, Gauhati, 4150. Next para, Ms. Divika, learned State Counsel, on the other hand, submits that the petitioner was only appointed as contingency sweeper on fixed pay White Office Order dated 24/4/1998. On our application for appointment on humanitarian ground. To stop, the petitioner never submitted any application for appointment on compassionate basis. And that the scheme for compassionate appointment has been introduced by the state government in the year 2002. To stop, the petitioner, therefore, to stop, moreover, the petitioner is appointed as contingency sweeper on fixed pay and not even enjoying scale pay. And therefore, question of regularizing her service does not arise. Stop. She submits that there are hundreds of other contingency workers appointed on fixed pay. And if the case of the petitioner, if the petitioner is given pay scale, if the petitioner is given the benefit of regularization, it would open floodgate for other similarly situated persons. What else would you like to submit? What is your stand in the affidavit?
Your Lordship, that is the stand only, Your Lordship.
That is the only stand.
Initially, that was the stand, Your Lordship, which has been refuted, Your Lordship, by submitting a citation by the petitioner. So basing on that, Your Lordship, the government has also ordered admitted possession, Your Lordship, now. But however, while considering his case, we should see that whether there's any station post. Since the petitioner is being appointed on a contingency.
She further submits that as per the addendum dated 9/4/2019, the criteria for considering compassionate appointment is strictly based in the order of date of death of the person. To stop, in other words, first preference shall always be given to those who have expired earlier. To stop, admittedly, the petitioner's name will not figure in the list. And therefore, the same would, and therefore, in the event a direction is given for regularizing her service, it would create a problem would be created. Since those already in line would be deprived of consideration, of preferential consideration. Stop. I have heard the submissions made by the learned counsels for the rival parties, and I have perused the materials available on record. There is no dispute to the fact that the appointment of the petitioner as contingency sweeper on fixed pay was on account of the death of her husband while he was working as truck driver under the Public Works Department, Changtongya Division. To stop taking a compassionate view of the application submitted by the petitioner, the Chief Engineer, Public Works Department, R&B Nagaland, had recommended her appointment as such. To stop, the petitioner has been serving in such capacity, admittedly, till date. To stop, against the request made by the petitioner, which was even forwarded and recommended by the executive engineer concerned. The state respondents have not made any, the respondent authority concerned has not made any consideration. To stop, in the present writ petition, through the affidavit in a position dated 26/4/2022, the state respondents have contended that the scheme for compassionate appointment has only come into existence through the office memorandum dated 13/2/2002. And therefore, the question of applying the said scheme to the case of the petitioner does not arise. Stop. However, the fact remains that the Government of India, in the Ministry of Home Affairs, Department of Personal and Administrative Reforms, through its office memorandum dated 23/5/1978, had already had formulated the scheme for compassionate appointment of son, daughter, and near relative of deceased government servant. To stop, the said office memorandum admittedly has also been adopted by the state government through office memorandum dated 1/8/1978, and also
13/6/1979, my lord.
13/6/1979. To stop, therefore, the plea of the state respondents that the scheme is non-existent. Scheme is non-existent at the relevant time, cannot be available to them. So moreover, appointment was given to the petitioner, as already noticed here and above, on humanitarian ground and on compassionate basis. Although the appointment does not reflect that the appointment is on compassionate basis, but the same is only on account of the expiry of her late husband, who was working as a truck driver in the department. Stop. It is further noticed that any such appointment on compassionate basis has to be on regular basis. This fact is also clearly discernible from the office memorandum issued by the state government in the Department of Personal and Administrative Reforms, White Office Memorandum dated 17/9/2015, stating that appointment on compassionate ground shall be made only on a regular basis to direct recruitment posts. Full stop. Therefore, upon due consideration, I find merit in the writ petition. The case of the petitioner is also not comparable to other contingency workers or to those who are not enjoying scale pay, or even to those who are enjoying scale of pay for consideration, for being considered for regularization. So therefore, the case of the petitioner altogether falls in a different category. Stop. The division bench of this court in state of Nagaland and Another versus Asino Sakri had has already held that the scheme for compassionate appointment formulated by the Government of India in the Ministry of Home Affairs, Department of Personal and Administrative Reforms, having been adopted by the state government, there is no denying of the fact that the scheme existed since the date of its adoption. Therefore, you cancel that. The division of there are no materials on record to show that the decision of the division bench of this court has been altered by a superior court. As such, the subject matter about the existence of compassionate scheme at the relevant time has attained its its finality. Stop. Thus, upon finding merit in the writ petition, the writ petition is disposed of with a direction to the state respondents, more particularly to the respondent numbers
2 and 3, my lord.
2 and 3.
Yes, ma'am.
To regularize the service of the petitioner against any,
Suitable post, my lord.
what is the grade or group?
Grade 4. Sweeper is grade 4.
Any grade 4 posts. As expeditiously as possible, and at any rate within the outer limit of 4 months.
My lord.
5 months, Your Lordship, then. At least 5 months, Your Lordship.
If something good is going to happen, let it happen immediately. Why? The period of 4 months. Make it 4 months. 4 months from the date of receipt of a certified copy of this order. Yes.
Deeply obliged, my lord.
For hearing, item number 32.
See, unless there is some urgency, I think I would like to rise. Anyone having emergency case?
My lord,
Yes.
here, the main cost list, item number 1441. Here, the parties are eager to dispose of the case.
Huh?
Item 40 and 41.
Yes.
So parties are ready for the argument, but if the issue is that the court has been tired.
In that case, we can try tomorrow. There's an urgency.
As a fixed item, giving a preference, because
there's urgency.
Yes, Lordship.
What is the matter about?
it's concerning with the religious institution and the association.
Correct. But what is the dispute?
The dispute is now the
property.
No,
No,
not
Lordship.
property. The functioning
Lordship,
of the functioning activities of the church.
Okay.
The petitioner has filed a writ petition.
The Registrar of Society, Lordship, the Registrar of Society has summoned for to this confidence of motion amongst the Luta Baptist Church Association. So we're challenging that order. It should be happened like this. The Luta Huhu has dissolved the Luta Baptist Church Association. Against the action of the Luta Huhu, we have submitted an application. So the Deputy Commissioner Oka has forwarded our application to the Commissioner Nakalin. The Commissioner Nakalin has examined the matter and has forwarded to the state government for decision. That is pending now. During the pendency of that, now the Registrar of Society, again, he has issued another order summoning the LBC to have a case of confidence of motion. Short meter ownership.
All right. So we'll
Tomorrow,
take it
Lordship.
up tomorrow.
As a preference.
State is also there, isn't it?
Yes.
All right. You remind the court tomorrow, after the part 1 matters are over, the hearing, before hearing is taken, and you remind the court, we'll see.
Yes, Lordship.
All right, as paid for by the parties, list the matter again for hearing tomorrow. 40 and 41. 32. Who's appearing for 32? What is this hearing matter? Mr. Jamir is there.
Lordship, my apology, I overlooked the post list, Lordship, and even the private respondent is not here, Lordship. Yes.
When?
After 3 weeks, Your Lordship.
As paid for by the London State Council, list the matter again after 3 weeks.
Lordship, much obliged.
It's a second appeal.
Yes, Lordship, yes.
Now you're handling the matter.
Yes,
Mr. T.B. Jamir's name is there,
Yes.
but you're conducting the
Yes,
case
yes.
now.
Lordship, my prayer is that on the last occasion also, the private respondent did not turn up. Even today also, he has not turned up. So, to that effect, Lordship, his non-appearance may be mentioned so that we can take up the matter next.
Then you write like this, since no one appears for the respondent. No, you just write one line. What did I say? As paid for by? Matter stands adjourned for 3 weeks. It is put on record that no one appears for the respondent today. That'll do.
Okay, Lordship, much obliged. Okay.